Assalamu alaikum. I'd just like to start by welcoming you all to this conference. I know we have guests joining us from the USA, Canada, Europe, UK, Iran, and across the globe, all on YouTube or via our Facebook live stream. My name is Mariam, and I am a member of the Executive Committee at SICM in North Harrow, London, otherwise known as Mahfil Ali. On behalf of the Executive Committee, I'd like to thank you all for joining us for this conference on Ayatullah Saanei. We've actually been told that this is the first conference of its kind since the passing of Ayatullah Saanei. Before we start, I just wanted to share a bit about the events that we usually hold at Mahfil. So every Friday, we hold lectures on various topics by experts in their field with the opportunity to ask questions after the talk. So just to give a few examples, a few weeks ago, we had a talk on the role of faith in the US elections. Last week, we had a talk on women and gender in the Quran by Dr. Celine Ibrahim. We're currently taking a brief break during the holidays, but inshallah, we'll be back on the 8th of January with a talk on Islam and liberation theology by Dr. Shadab Rahmatullah. Please do join us. They're currently taking place online and on the same YouTube page or Facebook page that you're on. To check out our upcoming lectures and find out about other events that we hold, please visit our website, sicm.org.uk. So that's SICM.org.uk. We also occasionally hold conferences like this on various topics. So alhamdulillah, it's great to have you all with us today, continuing this important work. Today's conference is being held to study the legacy of Ayatullah Saanei, who passed away earlier this year. He is known for having a distinctive approach on fiqh and usul al-fiqh, and we wanted to study this important personality and his legacy with experts who can give powerful insights. To do this, we have two panels. So the first panel will be on theory behind the law, Ayatullah Saanei's approach to Islamic law, and that will be from 12:30 to 2 p.m. Our second panel will be on practice, Ayatullah Saanei, a pioneer in reformist rulings in the Hawza, and that will be from 2 to 3:30 p.m. If at any point you'd like to ask questions to the panelists, you can do so by either commenting on the YouTube or Facebook stream that you're currently on. If you'd like to ask your questions with your video live, that is also possible. You can email info@sicm.org.uk and we can give you a link and instructions on how to do so. Or alternatively, you can send a message to one of the organizers on WhatsApp with your question, and that will then be asked. Right, so let's start the program with a recitation from the Holy Quran, inshallah.
أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. ولقد أنزلنا إليكم آيات مبينات ومثلا من الذين خلوا من قبلكم وموعظة للمتقين. الله نور السماوات والأرض مثل نوره كمشكاة فيها مصباح الله نور السماوات والأرض مثل نوره كمشكاة فيها مصباح المصباح في زجاجة الزجاجة كأنها كوكب دري يوقد من شجرة مباركة يوقد من شجرة مباركة زيتونة لا شرقية ولا غربية يكاد زيتها يضيء ولو لم تمسسه نار نور على يهدي الله لنوره من يشاء ويضرب الله الأمثال والله بكل شيء عليم. في بيوت أذن الله أن ترفع ويذكر فيها اسمه يسبح له فيها بالغدو والآصال في بيوت أذن الله أن ترفع ويذكر فيها اسمه يسبح له فيها بالغدو والآصال رجال لا تلهيهم تجارة ولا بيع عن ذكر الله لا تلهيهم تجارة ولا بيع عن ذكر الله وإقام الصلاة وإيتاء الزكاة يخافون يوما تتقلب فيه القلوب والأبصار يخافون يوما تتقلب فيه القلوب والأبصار ليجزيهم الله أحسن ما عملوا ليجزيهم الله أحسن ما عملوا ويزيدهم من فضله والله يرزق من يشاء بغير حساب رجال لا تلهيهم تجارة ولا بيع عن ذكر الله وإقام الصلاة وإيتاء الزكاة يخافون يوما تتقلب فيه القلوب والأبصار ليجزيهم الله أحسن ما عملوا ويزيدهم من فضله والله يرزق من يشاء بغير حساب صدق الله العلي العظيم.
Thank you so much. Thank you so much for that beautiful recitation. Now I'm going to hand over to Mahdia, who will be chairing the first panel and will introduce the panelists. Mahdia Abdul Hussein has a background in both Islamic jurisprudence and an LLM in medical law and bioethics. She is currently a faculty member at Al-Mahdi Institute teaching theology, legal theory and jurisprudence at an introductory level and coordinating the Institute's research activities. So Mahdia, over to you.
Our first panel today is entitled Behind the Law, Ayatullah Saanei's Approach to Islamic Law. And here we mean law in a broad term, which covers both the legal theory or the methodology and the jurisprudence. So we'll get a flavor through the next 3 talks about the framework which is actually used to derive the laws, as well as looking at the jurisprudence of Ayatullah Saanei and some of the specific issues that he's ruled upon, for example, equality laws. We're very fortunate to be joined by panelists who are experts in legal theory and jurisprudence. They've been lecturing and researching in the field for many years. I know that we've already been through this, but I think I should run through it again. If you have any questions, you can write them in at YouTube or Facebook, or if you prefer to come on live to ask your question, you can email info@sicm.org.uk to come on live. It's my honor to introduce Ayatullah Mohaghegh Damad to present the first paper on the jurisprudential school of Qom in the 21st century. Ayatullah Mohaghegh Damad is the Dean of the Department of Islamic Studies at the Academy of Sciences. He's also the Professor of Law and Philosophy at Tehran University. He was recognized as one of the world's most influential Muslim scholars by the Muslim 500 and has been invited in the past by the Pope to address the Vatican. Ayatullah Mohaghegh, can you please present your paper?
Alhamdulillahi Rabbil Alameen. As-salatu was-salamu ala Habib Ilahi Alameen ala Abdul Mu'ayyid wal-Rasul al-Ajab Abul Qasim Muhammad sallallahu alayhi wa sallam. At first, I would like to ask Allah for Ayatullah Saanei درجات من ومغفرة ورحمة وكان الله رحيما. I would like to ask Allah for Ayatullah Saanei strength from him, forgiveness and mercy, and Allah is all forgiving, all merciful. I ask my God to prepare for him forgiveness and great reward. Secondly, I would like to thank all friends who have done their best to execute this ceremony to compliment Ayatullah Saanei Rahmatullah alayh. I would like to thank my brothers and sisters in London and other places that they are listening my voice. The title of my paper is The Jurisprudential School of Qom. In the history of Ijtihad, in recent times, there are 3 ceremony schools of Samarra, Najaf, and Qom. The ceremony of Samurrah derived from Najaf and was instituted by Sayyid Hassan Shirazi, 1894. Despite not lasting a long time, it had a vast influence over the development of Shia society, both in politics and the method of ijtihad. It closed shortly shortly after the passing of Mirza Shirazi, and his learned student immigrated to Najaf carrying new ideals, a new method of writing, and a new method of jurisprudence. The head of the seminary of Najaf at the time were the two great marja, Sayyid Kazim, Sheikh Khurasani, and Sayyid Kazim Tabatabai. Yes. Khurasani's method in ijtihad was very rational. He had learned Islamic philosophy in Khurasan from Sabzawari, Mutahadi Sabzawa, the author of Mansurat al-Muntazamah in philosophy Islamic. And he had therefore mixed usul al-fiqh with many principles of philosophy in his famous manuscript Kifayatul Usul, which became a textbook for Islamic students throughout the world. He supported the constitutional movement in Iran and succeeded in the forming of the constitutional law of Iran, and he established a parliament for confirmation laws. One of the immigrants from Samarra to Najaf was Sheikh Abdul Karim Ayati Yazdi, who later became the founder of the Seminary of Qom, 1922. When he immigrated there, and a group of scholars and students joined to learn Islamic studies. His manuscript of Usul al-Fiqh was named Durar al-Usul. He lived in Qom for 15 years, and during this period he educated and trained about 400 men who were all at the level of Mujtahid and later reached the level of Marja, including Gulpaigani, Khomeini, Mohaghegh Damad, Shariat Madari, Marashi, etc. Whilst Shaykh Abdul Karim was educated in Samarra, he had a special aptitude and method of understanding Quran and Hadith, as well as teaching and educating. He had a special aptitude and method of understanding Quran and Hadith, as well as teaching and education. Some of the concepts he derived from the Holy Quran resulted in new fatwas concerning Islamic law. He was particularly concerned about women's rights. His heritage remains and can be seen in his pupils' work. When we say the Quran School of Jurisprudence, when we say the Quran School of Jurisprudence, we mean the same method established by the founder of seminary, I mean Shaykh Abdul Karim Ha'iri Yazdi. When Bhojani immigrated to 1944, the seminary started a new period, but continued to promote the seminary and was following the method of Shaykh Abdul Karim Ha'iri Yazdi. The special elements of the conduct of Bhojani and Ha'iri were the reading of the transmitted scriptures and what was quoted from the Prophet sallallahu alaihi wasallam and Imams alayhim salam. Bhojani emphasized the importance of the context of the hadith quoted from Prophet or Imams, the atmosphere of the time and the of the hadith. He also believed that Shiite fiqh was like a comment of Sunni fiqh. So understanding Sunni fiqh is a must for all Shiite mujtahids. Ayatullah Saanei is one of the second generation of educated mujtahid of the Qom school. He always was troubled over his rights, and in particular the rights of women. Examples of his ideas include his belief we cannot accept any discrimination between men and women based on the fact that God has said 5 times in Holy Quran that inna Allah laysa bighallamin lil abid. Allah is not tyrannical to the servants. He also recently said in an interview that the enacting of hudud in all times when the Imam is absent should not take place. My dear sisters and brothers, the concept that Ayatullah Saanei, based on this ayah, Inna Allah laysa bidhallamin abid, has reached to disadvantages that no discrimination between men and women is based on a very important idea about justice. You know that there is a controversial subject in Islamic theology. Ash'arite groups say that nothing, including justice, is not good and is not bad as well. Everything God says that is bad, it will be bad. And everything God says that is good, it would be good. But Imamiyya, the group of Imamiyya, as well as Mu'tazilite, believe that there are some deeds are good and there are some deeds bad. And all reason or intellect can understand without teaching of God. This subject is very clear. Everybody knows this. The difference between Imamiyya and the other groups of Muslims is Imamiyya names the name of group of Imamiyya Adliyya. Adliyya, that they believe to that understanding of Adl is very easy for everybody of people. But many fuqaha think that despite that we can understand, they say, we can understand by all reason that justice is good. But we cannot understand what deed is justice. God should explain for us what is justice and what is not justice. But Ayatullah Saanei and some other groups of fuqaha say all reason can understand what deed are examples of justice and what is not justice. Because God has no any definition of justice in Holy Quran. We can understand the definition of justice. This is what Ayatollah Saanei, based on many fatwas according to justice. Wassalamu alaikum وبركاته.
Thank you, Professor. That was very enlightening. You provided the historical overview of the different schools, which really sets the groundwork for the following talks, and mentioned that theological underpinning of the Adliya school, that justice can be understood by reason, and how this was utilized by Ayatullah Saanei in his own rulings. Just before continuing, I'd like to apologize for the problems we had in connection. Sorry. Next, I'd like to invite Dr. Ali-Reza Bhojani to present his paper on continuity and change in the interpretation of Sharia, Ayatullah Saanei on the legal status of non-Muslims. Dr. Ali-Reza Bhojani is a lecturer and coordinator and the co-director for the Center of Intra-Muslim Studies at Al-Mahdi Institute. He's also a research affiliate of the University of Oxford, and his research interests focus on the intersection between Islamic legal theory, theology, and ethics. Please can I invite Dr. Ali-Reza Bhojani for his paper.
Assalamu alaikum wa rahmatullah. I'm just trying to share a screen. Okay, Bismillah ar-Rahman ar-Rahim. Alhamdulillahi Rabbil Alameen. Wassalatu wassalamu ala Muhammad wa ahli bayti tayyibin at-tahirin. Okay, so an honor and a pleasure to have this opportunity to speak about the late great Ayatullah Saanei, especially with such a distinguished panel, both of whom, of course, are my teachers. And yeah, it's a great pleasure to have this chance to share some thoughts. So the title of my talk is Continuity and Change in the Interpretation of Sharia. Let me just adjust my screen. Apologies, for some reason it's not coming up fully. Okay, we'll try. Okay, hopefully you guys can see the screen. If not, please stop me. Bismillah ar-Rahman ar-Rahim. Okay, so the title of the talk is Continuity and Change in the Interpretation of Sharia, looking at a particular case of Ayatullah Saanei's treatment of the regulations, Sharia regulations pertaining to non-Muslims. So Ayatullah Saanei, as has been mentioned already, is associated with a range of distinctive fiqhi opinions. And he's been described in some of the secondary literature, within the academic literature, as institutionalizing a new method of ijtihad, and even a paradigm shift in 12 legal theory. And this actually, I want to say, has othered Ayatullah Saanei, positioned him as something very, very different, even by those who are sympathetic to his ideas. I actually want to build on the platform which Ayatullah Mohaghegh has given us and actually argue that his views are developed firmly within the mainstream Shia Usuli system. So as Ayatullah Saanei, as Ayatullah Mohaghegh described, Ayatullah Saanei was the second generation of the graduates of the modern Qom seminary. And his ideas, even these distinctive fiqh ideas, were developed within mainstream Shia legal methodology. And of the two key aspects which Ayatullah Mohaghegh has already emphasized, there's a commitment to this fundamental Shia moral rationalism that Ayatollah Mohaghegh introduced to us as this idea which is held as a fundamental principle of Shia theology, that moral good and moral bad can be understood independently of revelation, and the emphasis which Shias hold on divine justice. Furthermore, in his jurisprudential work, we see that Ayatollah Saanei elaborates on existing views, and he uses methods which are typical of Shia usulis. And I will argue that it is his commitment to tradition which allows for change across his fatwa. Because of his commitment to his ideas, it leads to what we might actually say radical change in his juristic opinions. And this can be seen in his views on the ahkam regarding the kuffar, which is the case that we will examine today. So for Ayatollah Saanei, very, very clearly, repeatedly, extensively, he elaborates and emphasizes that the kafir is a particular category of non-Muslim. It doesn't equal non-Muslim. So the kafir, in an apparent sense, the dhahir of this term, kafir, actually refers to an obstinate or stubborn denier, okay? Somebody who is jahid, somebody who has attained knowledge, okay? And as he puts it, the argument against him has been made in its entirety. So the evidence for truth has been made entirely, okay? And this kafir has actually recognized the truth, yet they persist in their disassociation with the truth and in their rejection of Islam. So this is the apparent sense of kafir for Ayatollah Saanei. The term non-Muslim then is more general, okay? The term non-Muslim includes somebody whose errors are blameworthy, the culpably negligent individual, somebody who is, if you like, a kafir in the above sense, somebody who's recognized the truth, okay, who has been lazy in the pursuit of the truth, okay, or still rejects the truth, somebody who can be held accountable for their errors. So non-Muslim includes such an individual, but also includes the innocently mistaken, those who are qasireen, those who maybe were unable to discover the truth, okay, or had some obstacles in their pursuit of truth, or have submitted to the truth to the extent that it was disclosed to them. So we see non-Muslim here is a broader category than kafir. And now usuli is a note here just to remind us as we go through that a fundamental principle, actually arguably of Muslim legal theory per se, is that we assume the apparent meaning of a statement is the intended meaning of a statement unless we have evidence to the contrary. Okay, so this basic principle of asalatul duhur, okay, is one where we assume a speaker means what they seem to be saying. Now, when it comes to the term kafir, Ayatollah Saanei, to repeat this foundational premise, is arguing that the apparent sense of the term kafir is that it refers exclusively to the obstinate or stubborn denier and not to all non-Muslims. Okay. So this view hasn't come from nowhere. It hasn't come out of the blue. There is clear usuli Shia precedent for Saanei's views in this case. Now, this is often described as a Mu'tazili view of the kafir, but I think that's too restrictive. We see this as a view which is built, okay, consistently in usuli thought, and I give some examples, or an example from modern Shia usuli ideas, and that is Mirza Qummi. So this was a first-generation student of Wahid Bihbahani, okay, where he's discussing in his work of legal theory the question of the salvation of non-Muslims. So for Mirza Qummi, non-Muslims are not destined for hell simply due to their incorrect beliefs, okay? So long as they are not stubborn before the truth, nor willfully negligent in the pursuit of that truth. Now, this idea to say that the innocently mistaken non-Muslim will not be punished in the afterlife by a just God is something which, of course, has precedent before him, Okay, and we see Mirza Qumi reviving the ideas attributed with the 9th century Mu'tazili thinker Al-Jahiz, but has also influenced Usuli scholars after him, a range of later modern Shia Usuli. So we see this idea picked up in Shaykh al-Ansari's works, in Ayatollah Khomeini's works, in Allama Tabataba'i's works, and in Mutahhari's works. Now, all of these guys had to respond to a certain question, and Mirza Qumi deals with it explicitly. So what about the consensus, the agreement of Muslims that the kuffar are amongst the people of the fire? The kuffar are min ahl al-nar. What was Mirza Qumi's response? Mirza Qumi's response to this is that that consensus can only apply to those who are willfully negligent, okay? Those who are blameworthy because of their incorrect belief. What were his justifications? Now, I mentioned these justifications because each of them are elaborated on by Ayatollah Saanei when he discusses the cases of non-Muslims in his jurisprudential works. So for Mirza Qumi, it says to punish one whose errors were despite their best efforts is an act of oppression. This is kabir and unascribable to a just God. If somebody's errors are not their own fault, we can't hold them accountable. They are qasir, they are not muqassir. And to punish them would be unascribable to a just God. Mirza Qumi goes on, he says, the apparent meaning of those texts from the Quran and in the Sunnah, which suggests that the kuffar are destined to the hellfire, should be read in accordance with the immediate sense of the term kuffar. What he refers to as the mutabadir, okay, of this word. And that is referring to those who are obstinate in their rejection of faith, those who are accountable for their errors, those who are willfully negligent, and not all Muslims. He cites a hadith to support his views, which we see later on Ayatollah Saanei also cites in his own justifications. And this is taken from Man La Yahdhur al-Faqih, reporting a portion of the second khutbah narrated by Imam Ali salamullahi alayhi on a Friday, where Imam Ali prays, Allahumma adhib kafarata min ahlil kitab. Oh God, punish the kafara, those who do kufr, from amongst the people of the book, those who place obstacles on your path, who obstinately deny your signs, and who reject your messengers. The point here is that this punishment which Imam Ali is calling for, okay, is from those who do kufr from amongst the people of the book. Going on to define, okay, who it is that this punishment is called upon, i.e. those who actively seek to prevent the development of Islam, those who obstinately deny, okay, or knowingly deny your signs and reject your messengers. Of course, for Mirza Qumi, despite this, he still felt that the innocently mistaken non-Muslim can be treated as a kafir in this world. So for Mirza Qumi, in the hereafter, okay, it would be immoral, unjust for God to punish the innocent non-Muslim for errors in their belief. But in this world, okay, the distinction between kafir and Muslim, okay, is not one which is considered immoral. Ayatollah Saanei extends this argument. Okay, he says that the innocently mistaken is not punished by a just God at all, in any sense of the word. All right, as Ayatollah Mohaghegh said, he has this huge emphasis, okay, on a theological notion of divine justice, you know, a Quranic basis of divine justice. And rationally, he elaborates on Mirza Qumi's argument, okay, citing that foundational theological adliya premise of qub al-iqab bila bayan, that it is blameworthy to punish without proper notice. Okay, it's immoral to punish without proper notice. Okay, if somebody hasn't fully understood the evidence, there's obstacles to their understanding of the truth, then clearly they cannot be punished. Okay, it would be immoral to punish them. It would be unfair if somebody didn't know any better to hold them to account. Yeah, or for Saanei to discriminate against them. He cites textual evidences to support this. For example, the famous ayah from Surah Al-Isra, وَمَا كُنَّا مُؤَذِّبِينَ حَتَّى نَبْعَثَ رَسُولًا. We do not punish until we have sent a messenger. Ayatollah Saanei, in his discussion here, points out how modern Shia Usulis typically use this ayah to justify, okay, the important principle of bara'a or exemption, okay, used in usul al-fiqh when there is a doubt about a possible duty. Now here, he points out how usulis have typically understood that messenger includes a sense of evidence, okay, or argument. So Allah subhanahu wa ta'ala accordingly can be understood from this verse to imply that we do not punish somebody until they have a complete argument or a complete evidence. He goes on to say that the Quran and the Sunnah explicitly identify or define the kuffar as those who are willfully negligent before the truth and are obstinate deniers or stubborn rejectors of the truth. He cites the same dua which we mentioned above from Imam Ali. He cites an extensive hadith from Imam Sadiq salamullahi alayhi on the different types of kufr and a category of kufr which is referred to as kufr al-ma'rifah, okay, in light of the ayah from the Quran 27:14, وَجَهَدُوا بِهَا وَاسْتَيْقَنَتْهَا أَنفُسَهُمْ ظُلْمًا وَعُلُوًّا, okay, referring to those in the times of Pharaoh who obstinately denied the truth despite having believed in it. I won't go into the details here because of time. He mentions, he cites various tafasir literature, seeks recourse from Allama Tabatabai and his own discussion of the 24th verse from the 45th surah, all to support and ground his views. You see, Ayatullah Saanei is building his ideas, okay, from a fundamental Shia theological basis, developed out of his reading of the Quran and Sunnah, citing precedent from his views amongst the ulama. Okay, finally, he goes to the lexical meaning of the term kufr, which means simply, okay, to conceal or to cover. He cites here, for example, the whole lexical canon, Ar-Raghib Isfahani, the Mufradat of Jawahiri, the Taj al-Lugha, of Firoz Abadi, Qamus al-Muhit, okay, Lisan al-Arab, so on and so forth, and also goes to cite some modern Shia usulis as well in their discussion of the linguistic sense of kufr, that kufr and kafir means to conceal or to cover. And of course, there is no concealment without understanding. Okay, so somebody can only be said to be a kafir if they have understood the truth and then they cover it or reject it. So with this package of arguments, which took their, which built from existing arguments that we see in the case of Mirza Qummi, Saanei argues that the apparent sense of the term kafir and the technical sense of the term kafir, okay, as understood in fiqh, should only refer to the obstinate rejecter, okay, not all Muslims in this world, whether it's with reference to this world or whether it's in reference to the next. Accordingly, for Ayatullah Saanei, the ahkam of kufr, the rulings regarding the kafir, do not apply to the vast majority of non-Muslims. So Saanei largely accepts the traditional rules that we find in fiqh, that we would find in, for example, the Urwat al-Wuthqa of Qadim Yazdi, which Ayatullah Mohaghegh mentioned. He would accept these traditional rules, but he changes their scope. For example, humans are assumed to be tahir, not ritually impure, as long as they don't have doctrinal obstinacy, what he calls inada dini, as long as they are not a kafir in the proper sense. So it's only the one who knows the truth and rejects it who has question marks over the ritual purity. The vast majority of Muslims, the vast majority of non-Muslims can be assumed to be ritually pure. The idea that zakat can be given to non-Muslims is something he advocates, so long as they are not kafir. Non-kafir, non-Muslims can inherit from a Muslim, and leaving Islam out of choice and an actual belief that Islam is wrong is not irtidad or legal apostasy. For Ayatullah Saanei, the rulings regarding irtidad and or what I'm translating here is legal apostasy were only for the kafir in the proper sense. Okay, the one who became an active and stubborn rejecter of Islam despite knowledge of the truth of Islam. So we see a remarkably consistent application of traditional ideas. He built these traditional ideas grounded on this fundamental acceptance of divine justice, okay, in light of precedent within Shia Usuli discourse, okay, but was frankly brave enough to apply this, okay, yeah, across the abwab of fiqh. I don't think this constitutes a new method of ijtihad, nor a paradigm shift in legal theory. It's just a commitment and a continuity, okay, very much with traditional ideas, irrespective of, you know, how provocative some of the conclusions may have been. So I'll give, if I have time, I think I still have 3 or 4 minutes, I'll give one final, bit more detailed example. And that was his view of regarding marriage with non-Muslims. And here we see, I've taken this from his Ta'lika ala Tahrir al-Wasila. So these are his comments to Ayatollah Khomeini's version of the famous Risala Amaliya. Okay, and he argues, he accepts that it's impermissible to marry a kafir. Okay, why? Because through his kufr, okay, defined as his covering of truthful belief and his stubbornness of opposition to belief, the kafir, like the mushrikun, invites toward the fire. And he's, of course, alluding to the 221st verse of Surah Al-Baqarah here, whilst Allah, with his permission, wallah, okay, bi'idnihi yad'u ila al-jannah wal-maghfirah, and whilst Allah, with his permission, invites towards the garden and forgiveness. So marrying the kafir is haram, in accordance with the prohibition which we find in Surah Al-Baqarah, and as Ayatullah Saanei puts it, the illah which is within that verse, that yad'u ila nar, they call, the kafir and the mushrikeen, okay, call towards the fire. But explicitly, Ayatullah Saanei says, this is not applicable to the majority of non-Muslims today. Okay, this is not the case for a non-Muslim who is not a kafir in that way. Somebody who's innocently mistaken in their unbelief. Somebody who is not stubbornly opposing the truth, or is under the protection of Islam and its security, or there is a pact of mutual respect and security between that person and the rest of the Muslims. I'm quoting here, like the majority of the non-Muslims today, if not the entirety of them, with the exception of those who are at war with the Muslims or those who assist them. So we see continuity, or we see change through a continuity with tradition. And for Ayatollah Saanei, actually still in this discussion, you know, in his extensive footnote on Ayatollah Khomeini's comments regarding nikah to a kafir, Saanei says it was, in his view, and of course he was a committed student of Ayatollah Khomeini, Saanei argues that it was only socio-political considerations which held Ayatollah Khomeini back on such matters. Okay, yeah, and we see that Ayatollah Saanei is positioning his ideas in continuity with his teacher. He's building on usuli precedent and method in light of fundamental aspects of Shia thought. He continues in that same note, emphasizing those points which have already been highlighted to us this morning. Okay, that Allah drives towards justice and the absence of oppression in his rulings. Any type of oppression is impossible for God. He mentions the verse of the Quran, وَتَمَّتْ kalimatu rabbika sidkan wa adla. The words of your Lord are complete in truth and justice. وَمَا رَبُّكَ بِظَلَّامٍ لِلْعَبِيدِ. Your Lord is not oppressive to his servant. And then he states that punishment of any sorts in the hereafter or in this world without full clarity, okay, without full exposition, okay, is immoral and something which cannot be ascribed to a just God. We see that Ayatollah Saanei, okay, used fundamental Shia resources, okay, in continuity with tradition for a contemporary rereading of the rules of Sharia. May Allah subhanahu wa ta'ala accept his efforts and bless his souls and allow us to benefit from those ideas which are useful to us and are good for us. Walhamdulillahi Rabbil Alameen. Mahdiya, we can't hear you. I don't know whether I'm still live or you're live.
you hear me now?
Yeah.
Yeah. Okay.
I hope you hear me during the talk.
I couldn't hear anything. I was just reading. No, I'm joking. I'll move on because I'm just conscious of the time. But thank you so much, Ali-Reza. The final talk is by Ayatullah Dr. Nobahar, which continues with case studies in law, looking at Ayatullah Saanei's approach to equality in Islamic law. Professor Nobahar completed seminarian studies in the Hawza of Qom and gained a PhD in criminal law from Shaykh Dr University. He was also a professor of law at Shaykh Dr University and is currently a faculty member at Al Mahdi Institute. Doctor, please can I invite you to present your paper?
Assalamu alaikum. Assalamu alaikum, Sister Mahdi.
Alaikum salam, Doctor. I hear you.
Do you hear me? And the quality of voice is good, and I have to continue, yes?
Yes.
Bismillah ar-Rahman ar-Rahim. Alhamdulillah, Rabbil Alameen. والصلاة والسلام على سيدنا ونبينا محمد وآله الطاهرين. Assalamu alaikum wa rahmatullahi wa barakatuh. I would like first to send the reward of Surah Al-Fatiha along with Salawat ala Muhammadin wa ala ali Muhammad to the soul of the late Ayatullah Saanei. Allahumma salli ala Muhammadin wa ali Muhammad. Bismillahir Rahmanir Rahim. Alhamdulillah. إياك نعبد وإياك نستعين صراط الذين أنعمت عليهم. I have to say salam to Professor Ayatullah Damad and my friend Dr. Ali-Reza, as well as Sister Abdul Hussein, who is the moderator of this beautiful meeting and event. And I also appreciate those who made many efforts to make this beautiful event possible. As Sister Abdul Hussein mentioned, I would focus more on the issue of equality from the point of view of Ayatullah Saanei, and I would present actually in three parts. First, I would mention some fatwas of Ayatullah Saanei which is relevant to equality. Then I would mention some methodological point which is behind these egalitarian fatwas. And thirdly, I would mention some bases and foundations by which we can probably develop the idea of equality to a broader and wider area. Alhamdulillah, before me, Ayatullah Damad as well as Dr. Bhojani mentioned some fatwas of Ayatullah Saanei, and again I would review some of those Fatawa which are more relevant to the issue of equality. I think the idea of equality in the views of Ayatullah Saanei covers a broad range. It covers the relationship between man and woman, wife and husband, father and mother, Muslim and non-Muslim, as well as some other issues like equality between, to some extent, equality of a legitimate and illegitimate child, a child born within the framework of marriage, and the child born out of wedlock. We know that Ayatullah Saanei is in favor of equality of the blood money or compensation of a man and woman, which means that the value of their lives is equal. Likewise, he believes in equality of the compensation and blood money of a Muslim and non-Muslim. And as Dr. Bhojani explained, he has his own understanding of this belief and kufr. Regarding the age of maturity, even though Ayatullah Saanei is not in favor of a categorical and absolute equality of girl and boy, however, he tried to make the age of maturity more equal by choosing and accepting hadith suggesting that the age of maturity in a girl is 13 lunar years, not 9 as it is in traditional view. In case of polygamy, even though again he is not categorically against polygamy, but he requires as necessity the permission and the consent of the previous lady in case the husband wanted to remarry. And this is, I think, even though this is not exactly equality, but it is one step, I think, toward equality. Interestingly, he believes that a lady and a woman per se not only has qualification and capacity to be a mujtahid, but also has a capacity when other qualifications are met to be a marja, a religious leader to be followed by others, which is, I think, a great fatwa and very decisive and critical. In inheritance issues, again, even though he is not in favor of equality, but some of his fatwas make more equality and balance between the share of the wife and husband from the inheritance of each other. As we know, in traditional view, according, of course, not to something consensual, but to something well known between jurists, the wife is often deprived from immovable properties like land, garden, and the building. Of course, the building has as an objection, but she has a right to inherit from the price of the building, but not from the building itself. Again, by reliance upon some hadith as well as some analytical interpretation of the related texts, Ayatullah Saanei is of the opinion that both wife and husband would inherit from the whole property they leave as the taraka, as or as the left property of each other. In case when the wife is the only heir of the deceased, as we know in traditional view, a wife has a right to inherit 1/4, and then the rest would be for imam or indeed government. But in Ayatullah Saanei's view, the wife as the single heir would inherit all the property, as it is the case in case the wife passes away and husband inherits her. When talking about the qualification of a judge, a religious judge, or a judge with religious qualification, we know that in the well-known or mashhur or famous opinion, the qualification of masculineness, dhukuriya, is needed. But Ayatullah Saanei denies this qualification and believes that a lady, when other qualifications are met, is quite eligible to be a judge. According to some fatwas, when a Muslim judge is facing a Muslim on one hand and a non-Muslim on the other as two clients of the court, of course, this fatwa is not well known, but it is raised and mentioned and said by some jurists. According to some, the judge has a right or permitted and even recommended to some extent to respect a Muslim more than, the non-Muslim client. But Ayatollah Saanei strongly rejects this fatwa and says this is against al-adl al-Islam. This is against Islamic justice. And of course, this list is open. And if we review the whole fatwas of Ayatollah Saanei, we can find certainly some more egalitarian fatwas, Fatawa, in which the idea of equality is seriously observed and actually attended. After mentioning these cases as an examples, I will move to second part of my presentation and will talk a bit about the methodology behind these fatwas. I'm quite sure that Ayatullah Damad mentioned the issue in precise and in detail. I'm quite sure he mentioned the school of Qom. But when talking about, in particular, about the methodology of Ayatollah Saanei, I think Ayatollah Saanei, to many extent, is very loyal to the traditional methodology. In every single fiqh questions, like any other traditional jurist, you see that he first studies the authenticity, reliability, and credibility of hadiths, the chain of narration. If the authenticity of the text is under doubt, he raises a lot of rijali and biographical questions about transmitters, and then he moves to the text and analyzes the content of the text. But here, I think basically there is a difference between Ayatullah Saanei and some others. As again, I'm quite sure Ayatullah Damad mentioned, we know that a large number of generation of jurists after Ayatullah Bhojani rahmatullah alayhi are to many extent under the influence of the methodology of Ayatullah Bhojani. And Ayatullah Bhojani is to many extent, we can say, a great contextualist interpreter. When analyzing the content of a text, Ayatullah Bhojani used to consider a broad and wide spectrum of contexts, from geographical context, mental context, historical context, and so on. We see this methodology in the manner of scholars and successors like Ayatollah Montazeri, as well as Ayatollah Saanei and some others. Moreover, his methodology has two other characteristics. First, as quite highlighted in the presentation of my friend Dr. Bhojani, is the importance of the idea of justice and its opposite, which is oppression. Every single fatwa which is against justice cannot be accepted. Dr. Bhojani pointed out to the idea of blasphemy and that all texts regarding disbelief and disbelievers, according to Ayatullah Saanei, are confined and limited to those who deny the right and truth deliberately, intentionally, with malice aforethought, not ignorantly. The lack of acceptance of something simply because of the lack of knowledge is not kufr. When talking about the share of the heirs of a non-Muslim, he says, how can we deprive the relatives of a person simply because he is a Jew or Christian or Zoroastrian and so on? When talking about murtad and blasphemous, he says in many cases the one who has grown in an Islamic family faces some doubts. According to traditional view, simply raising a doubt is a sign of blasphemy and being out of the Muslim community. Focusing on both a rational point of view, he says, is it right, is it rational to deprive someone from something simply because of having doubt about something? Is it just? Is it rational? So the idea of justice and injustice, likewise the idea of reason. All scholars, when talking in usul al-fiqh, talking about the sources of Islamic law and Sharia, of course, they mention reason along with Kitab, Sunnah, and Ijma as one great resource. But in reality, in many methodologies, the idea of reason is to many extent ignored. But here and there we can see the sign of reason in Ayatollah Saanei's reason. Let us mention some points, some foundations, some bases, if I am allowed and if I have time, Sister Abdul. If I have time, let me mention some bases and foundations which some are taken from Ayatollah Saanei and some by own humble consideration. By reliance upon them, we can develop the idea of equality. First of all, I think it would be very beneficial and important in terms of having a more equal Sharia law to reread, rethink, and even rewrite the principle of commonality in al-ahkam or in taklif. As you know, this principle has been mentioned in theology, in usul al-fiqh, as well as in fiqh. What does it mean? The presumption is that every single person is equal in whom certainly covers obligations and duties. But to some extent, it is ignored that this principle is quite capable to be developed to the concept of right as well. Because when theologians or scholars of usul al-fiqh or jurists talk about the concept of al-ishtirak fil ahkam, in no way they separate rights from taklif and obligations. So the powers both and taklif, right and obligation. The second base, as I explained, is to take the concept of justice serious, as we discussed here. The third base and foundation is to understand the very topics of discriminatory laws. If there is a source of discrimination is recognized for someone or for a group of people, we have to precisely understand the subject of the law, because law depends on a subject. So subject should be clarified. For example, suppose that there are some reliable authentic texts suggesting that a lady is not eligible to undertake the responsibility.
Dr. Nobahar, sorry to interrupt. Can you conclude next? Dr. Nobahar, can you hear me? Hello?
Hello? I hardly hear you.
Oh.
I just hear that you are telling something.
Can you conclude in the next 2-3 minutes, please?
Next
2-3 minutes? 2 minutes.
How many minutes?
3 minutes.
3 minutes?
3 minutes, please.
Says that you have no time. You have no time.
Okay, I understand.
Yes. She says you have only 3 minutes.
Good. I would finish in 3 minutes. Then we can also, so if I'm saying that suppose that there are a lot of text or reliable texts suggesting that a lady is not eligible to undertake, there is the position of, judgment and being a judge in Muslim community. But what does wife mean? Can we compare the wife in these modern societies to the ladies in previous and ancient societies? Is there any change in the subject? Also, we can consider equality as the ideal of the holy lawmaker, as the purpose, as the object of the objective of holy lawmaker. Because when we consider all measures of the Prophet, peace be upon him, we see, for example, when talking about women's rights, we see that all those efforts were in favor of equality. Shouldn't we follow the direction? We can also interpret and understand many discriminatory laws and regulations in terms of social issues. It is very common, even in the writing of scholars, great scholars like Allama Tabatabai and Ayatullah Mutahhari, that they justify some inequalities in terms of substantial and essential issues, like, for example, the substantial difference between men and women. But I think many differences are interpretable in terms of social issues, and therefore when social issues change, then the law certainly would change. We have also to be careful about negation and obligation versus negation of a right. To negate the right of the people, and in particular basic rights, is not easy. When at stake is an obligation and duty, we simply can rely upon the principle of acquittance, bara'ah, and say, I have doubt that I have this responsibility or not, and I will apply the principle of acquittance and bara'ah. But this is not the case when we are talking about a right. Depriving people from their right is not easy. And also we can say that to many extent we can separate between spiritual values and social advantages, social material advantages. If someone is a Muslim and he is in the eye of God the Almighty very good, very perfect, then it doesn't mean that at a social level he is over others. And finally, we have to understand that some unequal laws in Sharia are reactionary. This is very important. I put it at the end, but it is not necessarily less important. We have to consider that if some laws evaluate a non-Muslim as lower than a Muslim, these laws and these texts were established in a paradigm in which this was the case regarding others. I mean, non-Muslims also didn't see that a Muslim is equal to them. But when the whole paradigm is the paradigm of equality, we cannot simply rely upon those texts by ignoring these paradigm shift. I apologize for extending the time and for any shortcoming I had in my presentation, and I hope I could deliver the core of the message. Thank you again, Sister Abdul, and thank you everyone who made this event possible.
Thank you, Doctor. That concludes the 3 talks we had for this panel. We now have some time allocated for question and answers. Just to remind everyone, to ask questions, you can do that through the YouTube channel, through the Facebook channel, or if you prefer to come live, you just have to email info@sicm.org.uk and you'll be able to come live on. I think we have a question by Sister Afifa who does want to come on live. So if I could get her on to ask a question, which I think is to Dr. Ali-Reza. Also, when you ask your questions, can you direct it specifically to a panelist or a range of whoever you want the question to go to, please?
Assalamu alaikum. Can you hear me?
Yeah.
Okay, perfect. Thank you for the the talks. I have one question for Dr. Ali-Reza and one question for Ayatullah Nobahar, please. The question for Dr. Ali-Reza is, what objective criteria can one place to determine kufr? The standard, as you described, seems impossible to fulfill in terms of subjectivity and level of proof. So in terms of Islamic law, how would one determine who is a kafir? And then the second question is about the distinction between between equality and justice. So traditionally there's a difference between the two, and people would say that equality in Islam would actually be injustice. So how would we address that?
Okay, shall I go first?
Yeah.
Yeah, okay. Bismillahir-Rahmanir-Rahim. Thank you. It's an excellent question. So rather than give my own view, I'll try and, as I was trying to do in the paper, actually, I'll try to give a sense of what I think Ayatullah Saanei's view would be to this question, and hopefully Ayatullah Nobahar and Ayatullah Mohaghegh can help me as well. But I think for Ayatullah Saanei, he explicitly mentions on a few occasions something which can help here. So those who are actively in war against the Muslims, okay, they could be considered to be kafir. Okay, those who are actively, obviously at war and are actively, engaged in opposition, okay, they can be considered to be kafir. Okay, he also he also said, so in the case of marriage, he also mentions, it's not permissible to marry those people who are at war with Muslims, okay, and those who are assisting those who are in war with Muslims. But apart from those kind of very objective criteria, he actually seems to be telling us that our assumption should be that they're not kafir. The assumption is that the non-Muslim is a non-Muslim and not a kafir. We have to have evidence, actually, if I kind of use the language which Ayatollah Nobahar was using, we need evidence to restrict somebody's rights. We need evidence to attribute inequality in the rules of Islam to Allah subhanahu wa ta'ala. So where we don't have evidence, we would assume that they are not kafir. We would need criteria to suggest that they're kafir rather than the other way around. Okay, so this is my sense. And on one occasion, he's very clear when he considers about the tahara. He says, look, if we don't have evidence for their najasa, we only have evidence for the najasa of the kafir. So if you're convinced somebody is a kafir, you can consider them najis. If you don't have the evidence to consider them kafir, then the assumption would be that they're tahir. As we have from extensive traditions of the Ahlul Bayt, kullu shay'in laka tahirun hatta ta'lamu annahu najisun, or the general principles of tahara. So I hope that gives some sort of response to your question. Yeah, so an active, obvious opposition to Islam, okay, would be one criteria. Otherwise, our assumption should be, and in his view, he says it explicitly on a number of occasions, that the vast majority of non-Muslims today are simply non-Muslims. It may have been different at the time of the Prophet, actually. Whether it may have been different. For us to quantitatively is very difficult. But at that time, most of those, or at least certain periods, Islam was in constant war with non-Muslims. And we could say, arguably, most of the non-Muslims may have been kafir at that time. At the moment, in Ayatollah Saanei's views, he says the vast majority of them, if not all of them, with the exception of those who are in war or supporting war, can be considered to be non-Muslim and not kafir.
Ali, can I ask, just based on that, does that include countries which are at war with Muslim countries or not then? Because then
it's difficult. I don't know what his response would be there. Yeah, I really don't know what he's, but he goes very far. So, for example, he'd even say people, and this is where I guess the question of subjectivity and objectivity comes in, and ultimately it's about distinguishing the subject, not the ruling. Typically Ayatollah Saanei has given us the ruling. The subject now, those who are actually opposing belief. This is a question for identifying the subject, which maybe is the responsibility of the muqallid rather than the mujtahid. But he goes so far as to say even the modern day Khawarij, they should not all be considered to be najis, because most of them are just following a fiqh. Okay, most of them are just, so for example, if we think modern day Ibadis, they're following a fiqh which is attributed to the Khawarij. Right? They don't actively and bitterly and stubbornly oppose the truth. So for Ayatollah Saanei, even they should not be considered kafir in this specific sense. It's only if we are sure there's active opposition. But hopefully Ayatollah Nobahar can help me here. Yeah, or Ayatollah Mohaghegh if he's there to add any comments in response to this question.
Okay. Sorry, I don't. The second part of that question, Afifa's question, was to Dr. Nobahar. And is there a difference, Dr. Nobahar, can you hear me? Is there a difference between equality and justice? So sometimes giving equality to everyone is actually considered to not be injustice.
Sorry, Sister Mahdi. Unfortunately, I never ever heard, the question, and hardly heard what Ali-Reza, mentioned in response. Right now, I have the voice with a kind of actually disconnection. Repeated disconnection. I don't know what is wrong with the system. So if you hear my voice and I have to respond to something, you probably can write to me or what, I don't know.
Right, okay. I'll just carry on with Dr. Ali-Reza now. We're getting loads of questions on this idea of being at war. So there's a question from Rizwan Alibai, but surely the Prophet in Medina was also at war with the Munafiqeen, and the whole chapter of the Quran is dedicated to that. So does the same rule apply to them?
Yeah.
And it's at the bottom as well.
Sure. So I think there's a distinction between the Munafiqeen, okay, and the kuffar and the non-Muslims. Okay, major distinction. All right, and the Prophet would not be considered to be at war with the Munafiqeen at all. Yeah, during his period of during his life in Medina. Yeah? So of course the Prophet was at war with certain people from the Ahl al-Kitab, from the Mushrikeen, and certain non-Muslims more generally. Okay, it seems that Ayatollah Saanei's position, okay, is that when that opposition, okay, is with knowledge, okay, this is considered to be kufr in the realist sense. Okay, so yeah, I think his criteria is very clear. Actually, his criteria is very clear. Mirza Qummi, who I mentioned, he discusses this maybe in a helpful way. And because he made a distinction between somebody who's a kafir in this world may not necessarily be a kafir in the next world, or somebody who's treated in a kafir in this world might not necessarily be a kafir in the next. For Mirza Qummi, simply accepting, okay, or rejecting, the formal declaration of Islam is sufficient to consider somebody a Muslim. Okay, if you don't accept those formal aspects of Islam and reject something which would be a tantamount to the rejection of prophecy, you would be considered a kafir in this world. Okay, in the world to come, if that was out of obstinacy and stubbornness before disclosed truth, okay, that rejecter of Islam in this world would be subject to punishment in the hereafter. If it was an innocent mistake, he may have been treated as a non-Muslim in this world, but would not be treated as a non-Muslim in the next. Okay, Ayatollah Saanei is clearly going beyond that. All right. So the main argument which I wanted to make in my paper actually was to say that, look, whether we agree with these views or not, these views are built out of a commitment to fundamental resources within the Shia tradition, okay, and are built with precedents from within the Shia tradition. And I think as both Ayatollah Mohaghegh and Ayatollah Nobahar have emphasized, in continuity with Shia Usuli methodology. So as we can see from the questions, people are surprised with the implications of these questions, okay? Yeah, and to discuss them at length would be a lengthy task. So yes, some of these fatwa are surprising, but these aren't radical in the sense they're not a break with Shia methodology and Shia doctrine.
Yeah, that came through in all three of the papers. Professor Nobahar, I wrote to you, I don't know if you could see the question about equality and justice on the phone. No? Okay.
Yes.
Then we've got another question. We can write that at the bottom, I think. Did Ayatullah Saanei believe in khums or a similar concept of zakat as the well, it says as the Sunnis believe. So I think, can we put that question at the bottom? No? Okay. Okay, so back to Ali-Reza then. Sorry.
Did you ask me something?
Yeah, okay, you can hear. Is there a difference between justice and equality? Can you hear me, Professor? There's a question by Oliver. Then,
unfortunately, as I said, with repeatedly disconnection.
That's fine.
Just I know that you are talking.
Okay. We'll just move on then and hopefully try and resolve. Ali, back to you. Okay. So carrying on.
Maybe I can help briefly with that question.
Yeah.
Yeah. So I think that, of course, I think justice is a broader concept than equality. Okay.
Yes.
So it seems that equality, okay, can be, or maybe is usually, an instance of justice. Yeah. Okay. And for Ayatollah Saanei, it's obviously a very, very important instance of justice. But there's no doubt that justice is a broader concept, okay, than equality. He's still, and I think this was part of, maybe it didn't quite come out quite as clearly as Dr. Nobahar would have liked, but actually Dr. Nobahar recognized in his paper that Ayatollah Saanei isn't adopting, or wasn't arguing that, in every aspect, male and female, this, has equality. In fact, there were certain limits to Ayatollah Saanei's application and advocacy of equality. And in fact, Dr. Nobahar was suggesting ways in which, that could be moved further, beyond what Ayatollah Saanei has advocated. So justice is a broader concept than equality.
Dr. Nobahar, there's a question at the bottom. Can you see it? Can you see the question there? Dr. Nobahar?
Are you there? And do you see the question? And to whom the question is addressed, Sister?
The question is addressed to you, I think.
And do you
if
hear?
You can see the question. Yeah, can you hear me?
Do you hear me?
I hear you.
No extent, just unfortunate. But if the quality of my voice is acceptable, I can respond to this question if Ayatollah Damad is not over there. And
no, I think you can go ahead.
I think Ayatollah, in terms of zakat and khums, I think Ayatollah Saanei has almost a traditional view, and he doesn't replace actually zakat with khums. Zakat has its position, and khums has its own position. No, this replacement, to my best knowledge, is not mentioned and raised in Ayatollah Saanei's point of view. He believes in homes, certainly he believes in homes as in traditional view, but there is a view that homes simply was innovated and initiated due to something like an urgent situation, a situation in which a bad governor undertook the issue of homes, and then they misled it, and therefore when this situation is not current and common, then zakat would return in place of homes. This is one view, but to my best knowledge, Ayatollah Saanei has not such a view. Sister Mahdi, can I respond to this question, or? Yes, and do you hear me well?
Yes, I can hear you.
Okay, as I mentioned, it is something like a consensus between the scholars that in terms of the qualification of marja taqlid, the qualification of masculinity is needed. But Ayatollah Saanei denies this qualification. Even if you take a look at his Tawzih al-Masail when talking about the qualification of marja taqlid, it doesn't mention this qualification among the necessary qualifications. Also, regarding the presence of ladies and women in social issues, he was quietly in favor of presence of ladies in social issues, and due to these points and facts, we can say Ayatollah Saanei was to many extent a kind of egalitarian in sense of promoting the presence of ladies at social and political level. But if by question you mean something like practical issues, I don't know, but at the level of theory, Ayatollah Saanei was quite in favor of the fatwa itself, as I mentioned, was something actually critical and decisive, because probably this qualification is not mentioned in ancient traditional texts, but in recently published books. When talking about the qualification of marja taqlid, it is often repeated over and over again that this qualification is needed. But Ayatollah Saanei explicitly rejected this qualification.
Thank you, Doctor. Ali-Reza, maybe this one is for you. What would stop us from eating the food of Christians? Why do we have to go for halal food if the food of Jews and Christians and that of Hindus would also be acceptable?
Sure. So it's an issue which, again, Ayatollah Saanei was cognizant of. And so, again, I'm not trying to give my views here, trying to represent the views of Ayatollah Saanei. So he actually explicitly says the the condition which is typically cited for dhibaha, for slaughtering, okay, is not proper to include Adam al-Islam. Says at the most we can say it's Adam al-Kufr is required as a condition for rightful slaughter. There are other conditions for proper slaughter, okay, which he still maintains, such as the soundness of the slaughter itself. It should be of a particular form, okay, and the recitation of the Bismillah, but it doesn't need to be performed by a Muslim, Okay, so there are still obstacles in the view of Ayatollah Saanei from eating the meats of non-Muslims, but simply them not accepting Islam is not one of them. Hopefully that's clear. If I could, Mahdi, while I'm there, I saw, because I have the YouTube chat open, I saw a direct question to me, which says that, is it truly the case that Ayatollah Saanei was representing the traditional fiqh position in his ruling of irtidad? So this helps me just clarify what I was trying to argue. I think Ayatollah Saanei's method, okay, is in absolute continuity, okay, with the traditional Shi'i discourse. He developed, if you like, non-traditional views, Fatawa, okay, or new Fatawa. But, you know, as Ayatollah Mohaghegh Damad pointed out, actually it's part of the tradition of Shia ijtihad that mujtahids, okay, issue, okay, Fatawa, which have never been issued before, actually, whether we go to Alama Hilli or Sharif al-Murtaza, even further back, or in the examples which Ayatollah Mohaghegh gave us, from Mirza Hassan Shirazi through to Ayatollah Burjardi, giving new Fatawa is not against the tradition. Okay, and Ayatollah Saanei's method through which he came to these, these Fatawa which we've been discussing, okay, is I think, based firmly within the traditional Shi'i Usuli approach.
Ali, there's another question. I think we were speaking about this earlier, so perhaps it's best directed to you as well, about Ayatollah Saanei said that a woman can lead mixed prayers. Does he have any textual or historical evidence for this view?
Yeah, so this is a interesting position. Okay, so yeah, he argues, maybe I should open it actually to help me, all right, rather than just doing it from memory. So he does cite evidence, he does cite historical evidence, but I think largely he criticizes the condition. So again, typically fuqaha add, just as they do for marja'iyah, they add a condition that the marja, or in this case the imam of salat, should be male. Okay, so Ayatollah Saanei, if you like, criticizes that condition. Yeah, okay, we don't need evidence for the absence of a condition, we need evidence for the condition itself. And Ayatollah Saanei, in his comments to Ayatollah Khomeini's Risala Amaliyah here, actually focuses on criticizing the condition. Okay, he does mention some other historical evidence, actually. I can't recall it, but his main argument is against the condition, okay, itself. Maybe Dr. Nobahar can help in responding to that question.
Dr. Nobahar, would you like to respond? If we read the
I'm not quite fully aware of the whole arguments of Ayatollah Saanei regarding this particular, issue. The arguments and based sexual issues or historical issues. I'm not right now aware of the issue.
Okay. The sound is cutting again. There's a few questions which talk about, are there any other mujtahids who have a close methodology or rulings to Ayatollah Saanei? Ayatollah, it's going to have to be you. So in the terms of women being mujtahids or judges, yeah, and is there anyone else who takes a similar approach to Ayatollah Saanei? Which I know you spoke about, it's a historical development continuation, but are there any other examples maybe, or contemporary examples?
Sure, so I think for this, Ayatollah Nobahar would be best placed to answer, to be honest with you. But I think what we don't recognize or don't appreciate is that Ayatollah Saanei has been teaching and writing, in the Hawza for many, 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 many years. Okay, so he has had a huge impact, directly and indirectly, on the insight, on the mindset of contemporary fuqaha. So I have no doubt that he has influenced huge numbers of jurists. So of the likes of the, if you like, the third generation of Qum students, okay, of course they have been influenced by his ideas. And there are other streams of thinkers who have similar ideas, okay, but have taken different approaches. So the likes of Sayyid Hussein Fadlallah in Lebanon, but I think it's from a different stream. I think from the stream of Ayatullah Saanei, of course, we have the likes of Ayatullah Nobahar, who's sitting in front of us today, himself, okay, yeah, his colleagues, and I think many of the next generation of mujtahids, which will be coming out of these core centers of Qom, will share in these views and actually push these views further. I don't want to take the I'm sure that Shaykh Kumail Rajani in his session this afternoon will speak further on these issues and can give us more concrete examples.
And Miqdaad will also be covering it in his presentation as well. So I think that will be answered in the next panel. Maybe one more question. What was Ayatullah Saanei's position on doing taqleed or tab'id of a deceased marja? Is it allowed, only allowed if the muqallad was following the marja before the marja's death, or not allowed?
I don't know. Okay. I don't know. I reviewed some of his rulings on taqleed, and they were very much mainstream. But I really don't know, and I'm not familiar enough to respond to that question with his ideas.
Oh, just Dr. Nobahar, are you aware of that question, that answer?
Actually, I have no I think in mind I know about that. And this is quite available, of Ayatullah Saanei. Here, actually, we didn't want to explain whole fatwas of Ayatullah Saanei. Rather, we wanted to actually analyze and explain the lovely foundation, the basis of his Fatawa. Otherwise, his fatwas are available in different sources.
Yeah. So what I think, to summarize what Ayatullah Nobahar just said, is that the main aim of this panel was to look at the methodological and theological underpinnings of Ayatullah Saanei's work and how his commitment to them have resulted in some of his rulings, looking at particular case studies, but not necessarily just looking at different fatwas or all of the fatwas. So maybe that's something we can just look up later. There's one more.
Your voice, Mahfil.
Yeah?
I think Ayatullah Mohaghegh is trying to speak.
Okay. Ayatullah Mohaghegh, we can't see your camera. We can't see it.
Bhojani. Serious wrong.
Ayatullah Mohaghegh? Okay, we're having we're having a bit of trouble with our audio and connection to Iran, but I think that I'd just like to... No. I think perhaps if I just conclude this panel by thanking all of the panelists once again for their contributions. We do have to move to the second panel, which will be hosted by Sister Zahra. So if I could just hand over now.
Thank you very much. Assalamu alaikum wa rahmatullahi wa barakatuh. I would like to start with an ayah that has inspired and underpinned much of the later Ayatullah Saanei's work and has been referred to in the earlier panel, but does definitely bear repeating. بسم الله الرحمن الرحيم وتمت كلمة ربك صدقا وعدلا لا مبدل لكلماته وهو السميع العليم. The word of your Lord has been perfected in truth and justice. None can change his words, and he is the all-hearing, all-knowing. Surah Al-An'am, Ayah 115. It's an honor for me to be among so many teachers and students of Islamic jurisprudence. As a human rights lawyer and someone who is passionate about women's rights and the rights of minorities and justice more generally, it gives me great pleasure to chair this afternoon's session on practice, entitled Ayatullah Saanei, a Pioneer in Reformist Rulings in the Hawza. Two housekeeping matters before I introduce the first speaker for the second session. First of all, I'd like to apologize for any issues in connection that we might experience later this afternoon. I'm dialing in from outside the United Kingdom, so hopefully my connection will hold up and that of our speakers. But it's a feature of 2020 to be asking whether you can be heard and whether your connection works. So hopefully you're all used to it and you can bear with us. The second is a reminder, as you've heard earlier, there are 3 ways to ask questions. The first is to comment on the YouTube video, beneath the YouTube video. I'll see those comments directly and I'll be able to ask those questions of our panelists later on. If you would like to ask a question live, then please email info@sicm.org.uk, or alternatively, you can send a WhatsApp message to one of the organisers. To begin with our first speaker of this second session, Dr. Murad Goudarzi is an assistant professor of political science in the Department of Political Science in the University of Geylan in Iran. Dr. Goudarzi's current research interests center around human rights in Islam as Shia reformist jurist thoughts. The paper she will be presenting to us is Ayatullah Saanei's view on women and the rights of minorities. Dr. Goudarzi, please present your paper. Thank you. Dr. Masouma, you're still on mute. We can't actually hear you.
Salam.
Wa alaikum salam.
Bismillah ar-Rahman ar-Rahim. As you know, I'm a political scientist, and it was my concern regarding the rights of minorities in Islam and also the women's rights that brought me to the subject of human rights in Islam and in general and particularly in Shia jurisprudence. So I focused on the Shia marjas innovative fatwa, the marjas such as Marhum Ayatullah Mohaghegh, late Ayatullah Saanei, and Ayatullah Ibrahim Jannati, and some other jurists. The topic of my speak today is about theological and epistemological foundations of Ayatullah Saanei's view on women and minorities. Ayatullah Saanei presented innovative opinions in many controversial matters, especially in the subject of women and minorities' rights, which are rare or unparalleled in Islamic jurisprudence. Although the jurisprudential fatwas must all be based on sufficient evidence and reasons, but the theological and epistemological foundations of the faqih play an essential role in the type of the jurisprudential opinion issued by him. Therefore, without knowing these foundations and bases, the possibility of accurate understanding of the jurisprudential thought of faqih is difficult and perhaps impossible. There is no doubt that the type of epistemological and theological view of the faqih on the status, rights, and duties of human beings, and on philosophy of the creation, and more specifically, the abilities of women and its comparison with men, can influence the realm of his ijtihad in relation to minorities and women's rights issue. For this reason, it is necessary to fully consider and evaluate its theological and epistemological backgrounds before focusing on the fatwas. A review of Ayatollah Saanei's works show that he specifically emphasizes on 3 theological and epistemological principles as pre-jurisprudential principles for ijtihad in minorities and women's jurisprudence. These 3 are the principle of justice, the intrinsic dignity of human, for all, regardless of their race, religion, and gender, and the last, the human equality. First, I will deal with the Quranic foundation of the principle of justice. The jurisprudential mobility in Ayatollah Saanei's modern ijtihad is the product of his special and fundamental attention to the elements of justice and recovering its role and position in the process of inferring provisions, and also accepting the position and authority of collective rationality or urf in recognizing the concept and evidence of oppression and justice. Saanei believes that one of the most general and comprehensive principles of Islam for governing a society is to pay attention to justice and deny oppression. Therefore, this fixed principle, which can't be affected by locative and temporal conditions, should be used by the faqih for ijtihad and inference. He states that there are several verses in Quran in which the focus of creation is expressed on the basis of justice and justice is commanded. Verses such as, the decision is only for Allah, He relates the truth, and He is the best of decider. Or in other words, and the word of your Lord has been fulfilled in truth and in justice. And another one, and your Lord is not ever unjust to his servant. And the last example, that he should establish the truth and abolish falsehood, even if the criminals dislike it. This collection of verses clearly testify that God's words and rules are based on justice and righteousness, and that Allah does not oppress his servants neither in their creation nor in legislating, because he has established the basis of religious provisions and laws on justice. Another group of verses in Quran, such as Surah 2, Ayah 272, Surah 4, Ayah 40, Surah 4, Ayah 77, Surah 4, Ayah 70, and Surah 10, Ayah 47, all emphasize that Allah is free from oppression of his servants and does not impose oppression on them in the creation and duty he has assigned to his servants. Ayatollah especially states that according to the divine verses, the principle of justice is one of the general and fundamental principles of Islam and the basis and purpose of this religion. Collective human intellect also emphasizes that justice is an accepted principle and universal human value in which beliefs, gender, and ethnicity should not be involved. Consequently, according to the divine verses and the common human intellect, the principle of justice is one of the fundamental scales of Islam that governs other Islamic rules, and other rules are subordinated to it. One of the features of Ayatollah jurisprudential method is that he has greatly extended Ayatul Ahkam in Quran. For example, Faqih cited certain verses of Quran for the reasoning, but he also considers other verses as verses of ruling and uses them as the basic principles of argumentation for ijtihad, which include verses related to justice. Ayatollah Saanei believes that many general principles taken from the book and the tradition are superior to other jurisprudential reasons. The principle of justice is also one of the principles that are superior to other reasons and even to some other principles. He also explicitly states that the principle of justice prevails in all areas of jurisprudence except for the issue of worshipping practicing. According to the Ayatollah, the principle of justice is dominant in many fields such as social transaction or dealing, what we call it mu'amalat, hudud, blood money or diyat, or people's individual and social rights. The second principle that Ayatollah specifically emphasized over it is the principle of human dignity. He believes that people have some rights that are inalienable and cannot be ruptured. There is not any discrimination in the social rights between humans in Islam. Color, race, geography, location, religion, nationality, and gender are all subjects which, considering discrimination based on them, is a form of oppression. In Ayatullah Saanei opinion, human dignity is one of the most important principles which are repeatedly emphasized in the Quran, and it is mentioned a lot. Sorry. In Ayatullah Saanei opinion, human dignity is one of the most important principles which are repeatedly emphasized in the Quran and is mentioned a lot in the religious rules. He underlies that Allah sees humans as equal and he supports the rights of all of them. Ayatollah also pays special attention to verses that emphasizes on human dignity and considers it as a proof and evidence of the general value of human beings. And it is regardless of their gender. According to him, verses such as verse 14 of Surah 23 and verse 29 of Surah 15 show that human beings are all born with equal and same dignity. He states that Allah has spoken of two kinds of human dignity in the Holy Quran. One is intrinsic dignity, and the other is value or acquired dignity. The intrinsic dignity of human is stated in the verses 70 of Surah 17. And we have certainly honored the children of Adam and carried them on the land and sea and provide for them of good things and perfected them over much of what he have created. Allah spoke about the acquired dignity in verses 49 of Surah 13, which says, O mankind, indeed, we have created you from male and female, and made you people and tribes, so that you get to know one another. Indeed, the most noble of you in the sight of Allah is the most righteous of you. Acquired dignity is the product of human effort in life and how to manage one's behavior and actions. But intrinsic dignity is inherent in human beings since she or he is a creature of Allah and is considered his caliph. She or he has the power to distinguish between good and evil and has the power of choice. So these have led to the ability and merit of human being and the intrinsic dignity. According to Ayatullah Saanei, human is the supreme being in the world due to being human. In other words, the whole world of material and nature and even the supernatural world has been created for human beings. And all human beings have this dignity regardless of their beliefs, gender, and race. Another important principle in Ayatullah Saanei method is the special attention to the principle of equality, which forms his epistemological foundation for women's rights in Islam, that here I like to highlight more than two other principles. There is no doubt that the type of epistemological and theological view of the faqih on the human status and philosophy of creation of woman and its comparison with man can be effective in the field of ijtihad in women's rights issues, and its evidence could be seen in Islamic sources, especially in jurisprudence. From this perspective, what can be effective in the type of jurisprudential ijtihad in women's issue are several axes. To me, 5 of these axes are very fundamental. First, the philosophy of creation of man and woman. Does a woman have an independent creation like a man or not? Second, human status and existential structure and capability. From a humane point of view, is a woman a perfect being or an imperfect and incapable one? The third, perfection capability. Is perfection a masculine privilege or humane ability? The fourth, origin of goodness and corruption. Are women the main source of destruction and corruption? And the last but not the least, the fifth one, the value of deeds in this world and the hereafter. Are women worth less than men in this world and in the hereafter? How a faqih answers these questions both on a case-by-case basis and generally in ijtihad in the realm of ruling concerning women plays an important role in how to cite the existing reasons and interpret them. A look at the epistemological discussion presented by Muslim faqih and thinkers shows that until this date, epistemology in Islamic jurisprudence has been generally influenced by narratives and not Quran. Therefore, it is necessary to consider the view of the Quran in relation to the 5 questions that are mentioned above. In general, epistemological discussion have no independent place in the history of Islamic jurisprudence and have been discussed within other topics. Ayatullah Saanei is no exception in these general rules. In fact, he has considered it during jurisprudential discussions on various issues related to women over children and divorce. A brief look at the epistemological foundation of Ayatullah Saanei shows that he is a Quranic-oriented faqih, what we call in Farsi faqih Qur'angara. And in particular, in the light of examining the place of the human in the book, he analyzes the existence of human and his abilities and values. The narratives has been raised only to emphasize the existence of such a viewpoint between the Prophet and the Holy Imams. Here, I will investigate Ayatullah Saanei's opinion based on the 5 questions mentioned above, as much as it's possible, because we have limited time. So I just highlight some of the most important of them. Verses and narratives cited in proving the equality between men and women. From Ayatullah Saanei's point of view, the study of Quranic verses clearly shows that Allah considers all human beings to be the children of Adam and Eve, and does not differentiate between them in the origin and philosophy of creation and humane talents. Different gender does not mean difference between the inherent value of men and women in creation system. He explicitly emphasizes that men and women are equal in human variety, and they are equally talented and capable. To prove his claim, Ayatollah cites a set of verses and narratives that indicate the equality of human beings in creation, personality, talent, and other human characteristics. One of the verses cited by him is verse 13 of Surah Al-Hujarat, who considered piety as the source of human superiority. O mankind, indeed, we have created you from male and female and made you people and tribes so that you get to know one another. Indeed, the most noble of you in the sight of Allah is the most righteous of you. Ayatullah states that this verse emphasizes both on the equality of men and women at the origin of creation and in achieving perfection if they are pious. He considers verses 14 of Surah 23 as another proof of the equality of men and women in creation and consequently the equality of human beings and the denial of inequality in the rules and laws toward them. From Ayatullah Saanei point of view, the equality of men and women in creation and their ability to achieve the same perfection can also be deduced in verses 1 of Surah 4. This verse clearly emphasizes the human being as the human beings are equal in human variety and there is no difference between men and women, whether big or small, strong or powerless. Ayatullah invokes an ayah in Quran. O mankind, fear your Lord, who created you from one soul and created from it its mate and dispersed from both of them many men and women. It is obvious that Allah created men and women from a single soul and created their spouse from themselves. Another verse that Ayatullah emphasizes is improving the equality of men and women in creation and the ability is verse 6 of Surah 39 of Holy Quran, which says, He created you from one soul. The recitation of the Quran in general for both men and women. The recitation of the Quran is general for both men and women. They created you all from one nature. And in the word of creation, there is no difference between men and women. Being man and woman is not considered in the word at all. Being a man and a woman is a physiological issue related to the body. Humanity of human being is not in the body, but in the soul. Here I have emphasized over three most principles of theological and epistemological foundation of Ayatollah thoughts, but at the same time, I strongly believe that there are some other juridical principles that help Ayatollah to shape his innovative thought and innovative fatwa. I just want to highlight three of them to make a conclusion to my speech. From my perspective, from my point of view, the most important of them are the principle of unreliability of hadiths or narratives that are opposed to the spirit of the obvious teaching of the Quran. The second one is the content of textual criticism of hadith that Ayatollah had many emphasized over it, and he followed the late Ayatollah Burujerdi at this matter. And the last one is avoiding the abuse, avoiding the absolute following of famous jurisprudential ideas, what we call in Farsi Fatawa mashhur, and regarding specific views. Thanks for the time. Thank you.
Thank you very much, Dr. Mansouma, for that very interesting presentation. It's very enlightening to understand what impact the epistemological foundations of Ayatullah Saanei's thought was on the conclusions, if you like, of his analysis in relation to human dignity and equality. I hope we'll come back to some of your ideas in question and answer session. But unfortunately, because of the time, we now have to move to our second speaker of the session, Miqdaad Versi. As many of you may already know him, is a former student of the Al-Mahdi Institute, an executive committee member of the Shia Ithna Ashari community of Middlesex, and the head of public affairs at the Muslim Council of Britain. Miqdaad's paper is entitled A Whistlestop Tour of Ayatullah Saanei's Non-Mainstream Fatawa. Thank you, Miqdaad. Please do go ahead, Miqdaad. Thank you.
Assalamu alaikum. I'm just sharing my screen. Can you see it?
Yes, we can. Thank you.
Great. So thank you very much for that introduction. The way I'm going to introduce and approach this specific presentation is trying to cover a lot of material to give a real overview of how Ayatullah Saanei thinks and his approach. I'll give a short introduction to his background. I'll then go into his non-mainstream fatwa and their derivation and split them into two areas. One is defensible within the current traditional fiqh framework, and two, the second section, which is really the innovative approach, which is outside the current traditional fiqh framework. But as Dr. Ali-Reza and Ayatullah Nobahar and Ayatullah Mohaghegh Damad said, they're within the broad Shi'i tradition. And then I'll conclude. And so I just want to first set out some limitations about myself, that I am, compared to others on the panel who are far, we have professors on the panel, we have doctors who worked on this topic far more in far more detail than me. I'm a mere student, so it's worth just bearing that in mind. I am doing a whistle-stop tour, so that means that there will be lots of simplification and illustrative examples rather than covering everything. And I am focusing on Arabic sources. There are some in Farsi and Persian as well, but I'm focusing on Arabic because in the fiqh world, most of his works are in Arabic. And so just setting things up, as with all mainstream scholars, Ayatullah Saanei has written many different works in fiqh, and some of them are here. You've got your standard rulings on fiqh, just the actual rule themselves, and then where he comments on the views of other scholars and the fiqh works of other scholars in the margins or in the commentary underneath. He's done that to Ayatullah Khomeini, Sayyid Bahr al-Ulum, and the standard Uratul Wuthqa by Sayyid Yazdi. It's very, very common to do this, and that's what he has done. So it's very much within the tradition how he approaches this. And he's also published many detailed rationale. So whilst the commentary to some of the other scholars' rulings is there, that often is limited in the space and how much detail you can go into. So he has written a number of different works looking at the detailed istidlal and rationale on many different topics, on interest or on riba rather than necessarily interest, because you can argue it different ways, women as witnesses in Islam, and 15 different topics in these sort of short pamphlets. And they're not that short, they're about sometimes 80, 100-page long, but they are interesting, detailed discussions on each of these different topics, which you could, if you look through them, look quite clearly contemporary issues that many people might have questions on. And before I also go any further, I want to just define my terms. We've got two things I'm talking about: mainstream or non-mainstream, and by that I really mean mashhur. And so what I'm trying to do is focus not on Ayatollah Saanei's opinions that are, well known or well agreed, how to pray, etc. Like those are obvious. I'm not going to focus on those, not because they're not interesting, but because the focus here is really on the non-mainstream fatwa. Some people call them shadh, rare, or not mainstream. And the second area is the term I'm using is current traditional fiqh framework, and because I'm splitting the things out into the rulings out into two areas: those which are within the current traditional fiqh framework, and those are which are outside the current traditional fiqh framework. And what I mean by current traditional framework is this. So if you look as a whole, now this is a massive simplification of volumes of work of how usul al-fiqh works, but in summary, you have your sources of fiqh, Quran and Sunnah, and whilst you also have aql and ijma', as a whole, they're not really used in practice, and therefore I'm excluding them here. So it's the Quran and Sunnah, the Sunnah in terms of the actual written or tacit endorsement of varying reliability, understanding what these mean and how reliable they are. is one thing, that's one part of everything. But then the implications of that are create general tools of how you can deal with different situations, like practical procedures as to what you do if there's no sufficient evidence, specific fiqh positions like something is haram, and general fiqh rules like necessity or no harm. You have these, so you have your sources, you have implications, and then you have to determine what you do on the back of it. You know, when does something apply? How do you deal with different contradictions? Whether certain fiqh rules are applicable in certain, and whether they take priority or not, and whether you need to take precaution across everything. Now, what in red I've added here is each one of these areas is a very common area as to why there might be difference of opinion. So, for example, if someone might have a different view on the authenticity of a narration, that might be why there's a difference of opinion. Why some people might have a different view of what shahida or ru'ya means, and therefore on moon sighting they might have a different view. If someone has a different implication of a narration, there's lots of narrations on the tahara of Ahlul Kitab. If you have a different understanding of that, that might be a cause as to why you might have a difference of opinion. What the scope of the evidence is, ghina or shatranj, what do these actually mean? And what is the scope of what that word means in different contexts and different situations? Dealing with contradictions, we'll come to some examples there, and then applicability of qawaid fiqhiyya. So, for example, does necessity mean that you're allowed to remove the hijab in a French school? Those are examples within a standard traditional mainstream framework, which could be considered differences of opinion. I would argue that some of Ayatullah Saanei's opinions fall within that, and that's the first section, and some of them fall outside that, and they're different and they're new innovative ideas, but very much within the broader Shia framework and Shia tradition. So let me first focus on the defensible side of things, the ones which are very much within the mainstream framework. So here are just, again, this is a whistle-stop tool, so it's very, very brief. Here are just examples of opinions where his view is not mainstream, but I would argue fall very much within the mainstream methodology of deriving law. So consider the time of Maghrib, for example. The mainstream opinion is that the disappearance of the redness in the eastern sky is required before you can start praying Maghrib. But Ayatullah Saanei says that when the sun's disk goes below the horizon, the Urfi view of what Maghrib is, that's the driver of when you can pray. The condition of marja'iyah, which has been mentioned before, that it must be male, is the mainstream opinion, but his view is it can be either male or female, and we'll touch on that slightly right at the end. The best place for women to pray is at home, according to the mainstream opinion. He would argue in the mosque, it's very similar to men, he would argue. The interest paid on gainful employment of the principal is not allowed, but Ayatollah Saanei will say it is allowed. The purity of the non-Ahlul Kitab is, the mainstream opinion is that they're najis, but Ayatollah Saanei will argue that they're tahir if they are not obstinate. And Dr. Bhojani covered this in a bit more detail, so I won't mention any further. Ghina, what you might consider to be music, although there are different views as to how you translate that officially. The mainstream opinion is inherently forbidden, but Ayatollah Saanei would argue it's not inherently forbidden, but other things like lahul hadith or other specific things might make it haram, but inherently it is not haram. It's really interesting to see his rationale for that, and he talks about how Allah loves Jamal, Allah yuhibbul Jamal, and in part of his discussion on the topic. But there are 4 topics where I want to go into the istidlal, the reasoning behind how does he get to that conclusion. And these 4 areas I'm going to cover are the maximum age of bulugh for girls. The mainstream opinion is it's 9. Ayatollah Saanei says it's 13. And we'll go into that in a second. And with all these 4, we'll go into them in further detail. Playing with instruments of gambling, the mainstream opinion is not allowed, but he would argue it's allowed unless it's being used to gamble. The value of the testimony of women, the mainstream opinion is that's half of that of men on most general issues, and has no value in moon sighting, whereas in Ayatollah Saanei you will say it's equal to the value of men. And finally, women leading prayers of a mixed congregation, the mainstream opinion is not allowed, but Ayatollah Saanei says it does. So each one of these 4, I want to go into more detail. Now, there's a limit to the detail I'm going into here. Obviously, these are topics where there's 100 pages worth of rationale. I'm trying to summarize it in one slide, in 1 minute. So obviously, there's certain simplifications that I have made, and I apologize if in that case. So the age of bulugh for girls. Now, the core of his argument is that is firstly looking at all of the various narrations on this topic. Firstly, there's one group of narrations which imply that girls come out of childhood at 9. There's a second group which implies that, of narrations which imply it's allowed for a man to have relations with a girl after the age of 9. and 9 is mentioned as the age. And there's a third group which implied that the maximum age of bulugh for a girl is 13, and there's something about 10 as well. And Ayatullah Saanei first looks at those first two narrations, and he notices that there are challenges with the chain of narration in some of these. He would also know that when it comes to interpreting these narrations, he argues, and this is the core point that he makes, that the age of 9 is incidental. In all of these examples, or most of them, there are other factors mentioned, with the growth of pubic hair, gaining one's period, and in one of the narrations, it makes it very clear. She says, and that is because she has her period at 9. And because it's very explicit in explaining, giving the illah or the reasoning for that rule, he believes that the age of 9 that is mentioned in these narrations is incidental rather than a driver of the actual age of bulugh. And interestingly, many of the major Shia scholars of the past he mentions did not have the age of 9 mentioned until after Shaykh Tusi, where it was mentioned much more. And so what he does then, and in very standard way within Shia thought, is he tries to reconcile them. He tries to prefer one over the other. He then tries to say, well, if certainly a girl is not baligh before when she's born, but then the question is you're not sure when it's between the age of 19 whether she's become baligh, and therefore you have to assume she's not baligh because that's what the procedure is. Or you say there's no evidence for anything, and therefore you have to wait until you're sure, which is again 13. So in essence, this principle, this approach is very, very standard within Shia thought. So even though the opinion is different, the actual derivation is very similar. If you look at the instruments of gambling, he uses a very similar argument. So most people would say you can't use instruments of gambling. Ayatullah Saanei says actually you can. And his core argument is that the apparent meaning of the words that are used in the Quranic verses and narrations of Maysir and Qimar, especially in the context in which they're given, require monetary exchange. That's what the Arabic means in the context in which it was given. And therefore the Quranic verses are not applicable to games of chance where there is no betting. And therefore you are free to play with those games unless you are gambling. And this, again, the conclusion might be different, but the drivers of that are different, are very clearly within the standard framework of Shia thought and Shia fiqh today. Looking at the value of the testimony of women in general, the key thing here and the key verse of the Quran that's used is this idea, and of course there are the narrations as well, but if there are not 2 men, then 1 man and 2 women from among you who choose to be witnesses, so that if one of the 2 errs, the second of the 2 may remind the other, in Surah Baqarah. Now, Ayatullah Saanei is very clear. He says, look, we have something very, very mentioned here, so that if one of the 2 makes a mistake, the other 2 may remind the other. What is very clear is, therefore, that the woman, the likelihood of error is the reason why, in this case, women have a lower value in their testimony. The goal of the verse is very clear, that you want to reach satisfaction of what happened in that situation of the testimony. And that can happen independent of gender. And that's how ordinary people act. Expertise, not gender, drives the value of a testimony. And therefore, there's consensus. And just standing back a second, there is consensus that on some women-specific issues, the value of a woman's testimony, and this is a broadly understood and accepted fiqh rule, the value of a woman's testimony is more than that of a man. And so what is quite clear is from the Quranic understanding and from the Hadith and from the Islam generally, the expertise is what drives the value of a witness statement. And therefore he argues that the value of a woman's testimony is equal to that of a man, and any difference is dependent on their expertise. And I'd argue this is very much within the traditional framework because he's just having a different interpretation of the standard rules. One of the most controversial rulings that he has is where women lead prayers in a mixed congregation. Now, this is something that was mentioned earlier on by Ayatullah Nobahar and Dr. Ali-Reza, and in the question, I think one of the questioners asked this. And what is the basis for this? How can such a radically different review have be based within the traditional framework? And the reason is, in part, what Dr. Ali-Reza mentioned, which is that the base position and what is mentioned in many narrations is the importance of trustworthiness in leading prayer. And if you want to have a situation where trustworthiness is not required, so for example, young children cannot lead prayers, there needs to be a lot of evidence which is very clear, which says so. And there is when it comes to someone needing to be baligh before they can lead prayers. He also talks about the rule of qaid al-ishtirak, which says that in the absence of any evidence to the contrary, anything that's applicable for a man is applicable to a woman, because unless there's no evidence, you have to assume that it's applicable to everybody. And therefore, when you look at the narrations, what do you see? He then cites a specific narration. He talks about the hadith of Waraqah, noting it's a Sunni narration that states that the Prophet ordered her to lead the members of her household, which was not only women, but also men, in prayer. So he says, look, the base position is that anyone can lead. There's a hadith which says the Prophet allowed her and told Waraqah to lead prayers, which in a mixed congregation. And then he looks at all the evidence to the contrary, all the hadith which say that actually perhaps women cannot lead. And he goes through them one by one, and we don't have the time to go through them here. And he says that none of them are strong enough, either because of their chain of narration or because of what they imply, and they can be interpreted in different ways, to say that women cannot lead mixed congregational prayers. And so again, the conclusion might be different, but the actual derivation is very much within the mainstream. So what I would also note is that if you try and look at other scholars, Ayatollah Fadlullah is an example of someone who also had many of these similar non-mainstream rules, but very much within the mainstream theology, a framework in terms of how he went about doing it. If you look at one of the examples of fish without scales, it is, Shaykh Tusi talks about how it is, the consensus is so clear that someone who doesn't believe in this should be killed. That's the type of level of consensus. Yet Ayatollah Fadlullah was able to come to a completely radically different conclusion. And I can't go through it, I don't have time to go through it in detail, but in principle, he uses the traditional framework to come up with the conclusion that actually it's allowed. And that's not to say that Ayatollah Fadlullah was not innovative as well. He was, but I would argue that much of his theology much of his fiqhi rulings and approach is very much within the mainstream, even though there were differences in the approach that's been taken. Now, this section I really want to go into a bit more detail, and I want to say, let's look at Ayatollah Saanei in terms of the innovative approach that he's taken, where lots of his opinions are within the mainstream and are within the mainstream methodology. Some of these, however, are not. And we've had a lot of sessions today which talk about where this comes from. In part, this is because of how his primacy and centricity of the Quran, and coming up to two key principles, and Dr. Masuma talked about three, but I mean, the principles are the same, of justice, and there are lots of verses of the Quran which he talks about it, and equality. Now, what's really interesting is that in the current framework of how fiqh is derived, we very rarely see these two principles being used to overcome or take priority over specific sahih narrations. It just isn't used in principle. Now, whilst these are theological concepts that are there and part of Shia tradition and have been since time immemorial, the actual implication of them and how they are used in fiqh is very, very rare, especially within today's framework. And therefore, what I want to give a couple of quick examples. Firstly, looking at how a man is obliged to give a khul divorce. In other words, when a woman is asked, wants to have a divorce, she is able to ask the man, and the man has to give the divorce in that situation. And he argues that based on the obligation of forbidding evil, the fact that it is unjust to not give that. That's the core of his discussion. We don't have time to go into it in more detail. Similarly, the right of a man to demand more than the initial mahr when a divorce is requested, again, whilst there are some narrations which are very clear on this, and you could argue they're contradictory, he argues very clearly that using Quranic principles, and he talks about a lot of the principles in terms of justice in particular, this would not be appropriate at all. He also uses the Quranic principle that a husband must retain his wife with honor, imsak bil ma'ruf. And again, using Quranic principles in this way is unusual, not that common. The blood money argument was talked about a little bit by Dr. Bhojani, so I won't talk about it. But what I wanted to end with and conclude this section is whilst he uses these very interesting, very powerful tools of justice and equality to drive new rulings and different ideas, some argue that this would be outside the traditional framework, and I have said that. But you can also note that Ayatollah Khoui, and this is something which I find quite interesting, Ayatollah Khoui, in the discussion on gender being amongst the criteria of being a mujtahid, his main argument is not a textual one. He looks at the text and says there is no textual argument or that a man should be the mujtahid. He argues, however, that it is loved by Allah for women to be covered and away from others, and that it does not please Allah that a woman is on show like this. How would he and therefore he basically uses his understanding of his worldview of what the dhuq of Sharia, the taste of Sharia, which in essence is very similar to using these Quranic principles to drive this ruling. And therefore, you could very much argue that actually Ayatullah Saanei's views and his principles approach actually is similar to this dhuq of Sharia approach. And therefore, I'd like to summarize by saying, look, we've had a whistle-stop tour of many of these rulings and their derivation. We've talked about how many of them are innovative, but let's end with noting that some of the liberals might recognize that this is not someone who goes all the way. He doesn't, for example, say that the inheritance of men and women should be equal. He defends this in this ruling in speeches, and he says that the expenses are on the man, and therefore the inheritance should be remain in twice as much for a man compared to a woman. He does not give absolute right to divorce to a woman. He says that a man has to give the whole divorce, but it's not the man has to still give it. He doesn't say that polygamy is prohibited. So many people might say, actually, maybe he could go further. Despite him being a mujaddid, despite him being a reformist, there are areas where some reformists may have different views. And therefore, it'll be interesting to see how the next generations build on this. And Shaykh Kumail will cover this in further detail. Thank you very much.
Thank you very much, Miqdaad. That was a fascinating summary. You've introduced very well what the next session will cover. So I think I'll just go straight into that. Shaykh Kumail Rajani, just a brief introduction, and the more detailed biographies on all of our speakers are available in the program. He is currently undertaking postdoctoral research. He's a postdoctoral research fellow in Islamic Studies at the Institute of Arabic and Islamic Studies at the University of Exeter, where he's currently working on the Law Authority and Learning in Shiite Islamic project, with Professor Robert Grieve, funded by the European Research Council. But also it's notable that Dr. Rajani has undertaken seminary studies in Qom for over 17 years. So we're very fortunate to have his insight and experience through his paper entitled The Future of Progressive Thinking in the Hawza. Please, Dr. Rajani, could you give your paper, please?
Yes. I just want to share my screen. Just bear with me while I... Yes, sorry for that, and I hope now you can see my screen. So, Bismillah ar-Rahman ar-Rahim. The topic which I am going to discuss today is the future of progressive thinking in the Hawza. So let's have a brief outline before I begin my presentation. So in today's session, you would be expecting in this session a brief outline. I just want to keep my watch as well. So a brief outline of what we are going to discuss. So first of all, introduction, the current state of Hawza, because when we want to discuss the progressive thinking, the future state of progressive thinking in the Hawza, I believe it is important to look at the current state as well. Features and characteristics of progressive trends within the current various streams of Hawza. And lastly, we'll be discussing expectations. So let's begin with introduction. So first of all, introduction would be we would be discussing some terms and terminology. So when we say progressive thinking, what do we exactly mean by progressive thinking? So briefly, what I was thinking about progressive thinking, I would like to share my thoughts on this. So critiquing the orthodoxy or what is perceived to be orthodoxy in a scholarly framework while remaining committed to the tradition. So that's what I actually mean when I refer to progressive thinking in today's session. So it is something within the tradition, the change, the yearning of change, which is coming should be within the tradition. If it's out of tradition, that's not what I mean by progressive thinking. When we'll be discussing Hawza, I mean the religious institutions where rigorous debates are taken, are conducted. In today's term, we would be calling seminaries as well. So I would be changing the word seminary and Hawza quite frequently in this presentation, but actually I mean one and the same, those religious institutions. The larger questions which we would like to focus and try to reflect is about what is the aim and what is the mission of Hawza? What does Hawza aim to contribute? There might be two different ways of thinking. Some might think like, Hawza is a center to produce muballigh. The fundamental duty of Hawza is to train preachers who could go and give sermons, who could solemnize marriages, who could lead prayers and fulfill the religious assisting Muslim communities in their day-to-day lives to conduct their religious ceremonies. So that could be one answer. But the other way of looking about what Hawza aims to contribute is that Hawza wants to participate in wider debates and contribution to larger questions of humanity, of science, of trade and commerce, of ethics, and so on and so forth. So we will have to look what exactly Hawza aims to contribute, and depending upon our answers, whether the Hawza is thinking about producing muballigh or acting as a research sort of institution who wants to contribute and participate in wider debates, our way of looking at Hawza would be different. Based on my experience and what I read and hear from the seminary is that Hawza wants to contribute and be an active participant in the wider debate in what humanity at large is grappling with in 21st century. If we were to look about Shi'i seminaries and Shi'i scholars, you could see from 17th century on in this graph, you see a rise in number of scholars in Shi'i seminaries and in Shi'i intellectual tradition. 17th century is the beginning of Safid period. Except for 18th century slightly, it has always gone upward, and the climax is in the 20th century. So this is what we will have to remember when we discuss about seminary and history of a seminary or a Hawza. Let's begin with, after this introduction, let's begin about discussing the current state. When we say about the current state, I would like to emphasize that this presentation would be focusing mainly on Qom. Najaf, I am not qualified to speak about Najaf given my lack of experience. And number two, Najaf does not appear to be that vibrant to me compared to Qom in different disciplines, as we would discuss. So I would mainly be focusing on Qom in this presentation. So when it comes to emerging trends of progressive thinking, we would like to focus on three elements and three dimensions to this topic. Number one, about research institutions. So if we were to look in contemporary Qom, Hawza is not a traditional sort of a place where old texts of Sheikh Tusi and Allama Hilli are discussed of 17th century, 7th century after Hijrah. Rather, it's a dynamic sort of environment where some might be surprised. Aristotle and Plato are widely read. When it comes to hermeneutics, Gadamer is critiqued, and the opinions of hermeneutics are, and the scholars studying hermeneutics are widely discussed and debated. When it comes to different religion, there is a center in Qom affiliated with Hawza and affiliated with Shia seminary, where they discuss all and different religions. When it comes to the different philosophies. Allama Tabatabai was introduced to Upanishad through some of his students, like Hindu texts. So it's like a dynamic environment where you would find all the debates and all the disciplines are discussed and debated critically. When it comes to discipline, Hawza is no longer a place where traditional fiqh is studied. Rather, fiqh has been divided into various substreams. Like, in today's Hawza, it's not just like, the ruling of prayers. Rather, you have fiqh tarbiyah, like, the fiqh which is related to upbringing, fiqh al-iqtisad, the science and the jurisprudence of economy. Before that, like Shaykh Sadr is a falsafatuna, iqtisaduna. So all these disciplines which are emerging are a result of those emerging trends of progressive thinking in modern Hawza and contemporary Hawza. When it comes to leading scholars, let me mention some of the scholars, because I see Ayatullah Saanei not as an isolated example, as we have discussed in various presentations, throughout various presentations. The Ayatullah Saanei needs to be seen in a series of scholars who have contributed widely to this progressive thinking and progressive ideas. So let's take names of a few of the scholars. We won't get into the details of their opinion, because partly they have already been discussed in today's this online conference. So first we will look at like late Ayatullah Fadlullah. I have been very selective in taking names about like progressive thinkers in contemporary Hawza. But let's take it some representative examples. So Ayatullah Fadlullah was a leading scholar, studied in Najaf, then in Lebanon, one of the bastions of progressive thinking as far as Hawza studies is concerned. We have late Ayatullah Saanei. Ayatullah Saanei comes from that background. Again, I won't necessarily, I know I would be disappointing some of the listeners and some of the viewers, but Ayatullah Saanei is not among those leading scholars from the progressive thinking, because if we were to classify, we have like top-notch tier of like scholars, likes of Ayatollah Wahid Khorasani, Ayatollah Shubiri Zanjani, not grouping them into progressive scholars. What I mean to say that in seminary there is a top layer of like scholars who have contributed to traditional thinking and to orthodoxy immensely, teaching from last 60-70 years. Ayatullah Saanei would not fit, and I want to be very clear, he won't be fitting in that top one tier scholar. But I would frankly say that we don't have any progressive thinker scholars and mujtahideen in that first top tier layer. So Ayatullah Saanei would be coming in a second tier of scholars, of contemporary scholars. When we say about second tier scholars, again, I want to be very clear, his contribution to progressive thinking has been immense, but comparatively and relatively, likes of Sayyid Kamal Haidari are far wider listened to, and they have like many books, many scholars, and their legacy is profound. So we need to think all the scholars as far as their streams are concerned, they converge at some point of time, which we would like to call it progressive thinking, but their methodologies, their approach might be quite different, and their popularity and their contribution to progressive thinking, to the discourse of progressive thinking, would be different as well. So I see Ayatullah Saanei as one of these leading scholars, as opposed to the main leading scholar. We have late Ayatollah Sadiqi Tehrani, whose progressive thinking was completely based on Quranic principles and Quranic approaches, likes of what we would see in Egypt and somehow like in Indian subcontinent, we would like to call them Quraniyun or Quranist. We have Ayatollah Ibrahim Jannati. So, for example, Ayatollah Ibrahim Jannati is far radical, quote unquote radical, in terms of the fatawas compared to late Ayatollah Saanei. but simply for the fact because Ayatullah Saanei had that political affiliation with certain groups right from the beginning of revolution, and being a public figure, his popularity is wider. Otherwise, like Ayatollah Ibrahim Jannati, if we were to look at his Fatawa, they are quite revolutionary compared to Ayatullah Saanei. Sayyid Kamal Haidari, we all know his name and his popularity. He's one of those leading scholars who is defining, and based on sort of my readings, he is coming up with a framework which is very consistent in his articulation, as well as like in the derivation of Fatawa, and is quite challenging upfront in what he believes and what he's researching on. We have Sheikh Haidar Hubbullah, emerging scholar, again from Lebanon, likely like Sayyid Kamal Haidari, discussing and pushing the boundaries and contributing to the progressive thinking of the Hawza. We have Sheikh Surush Mahallati, again one of the leading scholar, the second generation of Ayatullah Saanei, but immensely contributing to progressive thinking in the Hawza. So that's the current state. Let's think about what is the backlash. I mean, this is the current state. We have named the scholars. We know some of their ideas we have discussed today. So where the resistance come? Because when we want to discuss about the future state and the future of progressive thinking, it would be vital to see where are the obstacles. So again, what I'm reading and what I'm hearing from the Hawza, and based on my experience, I think the resistance to progressive thinking comes from three different ideas. So number one, the idea is Hawza tradition has a long-lasting traditions of deference to elders, to seniors, to previous scholars, to early, to classical, to pre-modern scholars. There is a sense of respect, which at times it prevents them from critiquing. So likes of Sayyid Kamal Haidari, likes of Ayatullah Saanei, when they come up with this modern ideas or what we might call progressive thoughts, the traditional, the orthodoxy would see is as a sign of disrespect, irrespective of that being true or not. That's a secondary question, but this is widely seen. So when there is a sense of deference to early scholars, critiquing them is a big challenge. So that is the challenge which the progressive thinkers in today's Hawza, they face a lot. The second dimension is traditional school comes from the background of preserving the divine text, the letter of law. There is a legacy of 260 years of traditions, what imams have stated, what imams have preached, which is in the form of riwayat and narration. So those divine texts, when it's text, I mean the letter of law, that has been considered as sacred, as something which is divine, which is untouchable. So when someone pushes the boundaries, when someone tries to read between the lines or goes beyond the text, that is something, a no-go area for traditional scholars. So that is one of the obstacles which progressive thinkers faces in today's Hawza, in contemporary Shi'i seminaries. The third element which comes from the traditional school is a fear of Sunnification, fear of westernization. For example, likes of Sayyid Kamal Haidari, when they push the boundaries and try to argue against the Gulati beliefs, or some of the things which he might think is inconsistent with overall ethos of Islam and Islamic principles, and might be closer to Sunni reading of Islam. That would be again a no-go area, simply for the fact because traditional camp would think that Shiites should not be Sunnified, right? Because if that plot is lost, there is a risk of getting closer to different groups. So that is something which I think it's an obstacle, and there is a resistance resistance to progressive thinking from traditional school of thought. And besides Sunnification, we should be thinking about westernization, because when it comes to progressive thinking, they might like to have their ideas aligned with humanity at large, like, you know, different discourses which are debated and discussed and critiqued in academia, in universities, in political platforms, and they want to participate in that, and for that reason they might be reading, they might be influenced. Influence, by the way, it's not a negative word. What I'm saying is, like, you know, it's always give and take. So that is something again considered to be an obstacle for progressive thinking when it comes to their research. Let's think what Rasul Jafri, again one of the leading scholar, although he does not claim to be an expert in law and legal theories, or, like, you know, fiqh in general. Rather, he's a celebrated historian and an accomplished scholar. He says, and I'm just quoting from one of his articles in 2012, he says, "Our current situation is similar to the end of the Safed period. We have no choice but to change." So that is something he is feeling and he's anxious about, like, you know, he's demanding for some change. So what next? What we think about the future of the progressive thinkers? And I have just, like, you know, less than 4 minutes left. So first of all, Quranic centricity. So the progressive thinkers would always like to think, like, you know, Quran is not just, we shouldn't be diluting Quran within 500 words, because when it comes to legal scholars, when it comes to fuqaha, mujtahideen, ayatullahs, they would claim that, you know, Quranic verses related to fiqh are just approx like 500 less or more, not more than that. Whereas progressive thinkers would be thinking far beyond that. They would think, like, you know, entire Ayatullah Hadi Marifat, in one of his works, he mentions, like, you know, Quran should not be diluted, even when it comes to the discipline of fiqh, shouldn't be diluted to 400 verses. Rather, the entire Quran could be studied and looked at it from a fiqh and legal angles. How to do it is completely different topic. Qawaid fiqhiyah. So some of the material Dr. Goudarzi has already discussed. The aim of the progressive thinkers and what they want to contribute is, like, you know, we can't have new material discussed with old techniques. I appreciate, like, you know, always Shiism has been adliya and what we have discussed today, and still there is a hope that from current discourses we could still elevate fiqh to reach to the next level. But the progressive thinkers would say, like, you know, we need to design and devise new forms of maxims based on which we could be we could have a more free hand to derive different rules and things. So what Miqdaad discussed, just like, you know, in previous presentation, definitely there is a room of working with the material which is in our hand, at our disposal, but new material needs to be devised and researched. So how to go forward, as the progressive thinkers would like to contribute, is, like, you know, we have individual reports through which we would be working. But when it comes to al-qawaid al-fiqhiyah, legal maxim, are not, like, you know, isolated individual report. Fiqh cannot be built on those one or two riwayat in different parts of various books. Rather, fiqh needs to be thought through in a pattern of principle-based derivation. When I say principle-based derivation, I mean, like, you know, in the form of al-qawaid al-fiqhiyah. So the current qawaid fiqhiyah which we have at our disposal are limited. We need to think far beyond those. So some of the ideas which we have discussed, like, you know, the principle of justice, the principle of karamat, the dignity of human beings, principle of equality, equity. So all these things are, like, you know, each and every material needs to be discussed and widely debated. But see, these are the principles which the progressive thinkers would like to contribute to the discourse as far as progressive thinking is concerned. New interpretive tools. So it's not just, like, you know, al-qawaid al-fiqh, or you devise legal maxims. Rather, the legal theory, the jurisprudence, the principles of jurisprudence needs to be revised and redefined as well. So those tools and techniques needs to be developed. So for example, like, the traditional fiqh goes as far as the riwayat are concerned. So you take one hadith from Al-Kafi or from any other book, you give your fatwa and your opinion based on that particular riwayat. Whereas, like, progressive thinkers would say, like, the hujjiyah of al-khabar al-wahid, the probative force of or like authority of these reports, singular reports, should not be taken seriously when it comes to make decisions which is going to have far-reaching impact on the different things, on inheritance, or like, the life of an individual, or purity or impurity of human beings, right? Or like, global issues.
I'm sorry to interrupt. Could you please wrap up soon so we can have some questions and answers?
Sure. Integrating fiqh with other disciplines, that is something which progressive thinkers would like to contribute in their discourses as well. So what are the expectations as far as those tools and techniques we already discussed, but other expectations which progressive thinkers would have, and what we see the future of progressive thinking in the Hawza? Critics should be welcome, because that is something progressive thinkers are nervous about. Second thing, Hawza needs to be defined, whether it's a preaching center or a center which wants to contribute to larger debates. Akhbarism and akhbari attitude. Although the traditional school might appear as an usuli trend or usuli sort of school, but progressive thinkers have their critiques on the traditional camps being more inclined towards akhbarism or akhbari attitude. At times in fiqh, you might see usuli approach, but when it comes to kalam or like, other discourses, the trend is more of an akhbari nature. Translations, engagement with universities, both within Iran and in other places, both in East and West, that is something needs to be done. That belongs one of the expectations of progressive thinking. And lastly, about political freedom, touching upon subjects which are politically considered to be untouchable areas, needs to be made free as well. So these are like, some of the debates and some of the expectations of progressive thinking which I have been reading. Thank you.
Thank you very much for that overview. For my part, at least, it's very exciting to hear how Ayatullah Saanei is not a lone voice in terms of progressive thinking within the Marja'iyya, and not only not a lone voice, but also not the most radical, we're told. So I'm going to be doing some research after this conference to find out some more about the others you've named. We have some questions already, and a reminder that if you would like to ask a question, you could either email info@sicm.org.uk or write your question underneath the YouTube video, or send a WhatsApp message to one of the organisers. Can we go to Sister Afifa, please, who's got a question she wants to ask live?
Assalamu alaikum. Can you hear me?
Yes.
Okay, so I have two questions for Dr. Goudarzi, actually. Thank you very much for your talk. So the first question is that in the traditional account of the creation story, we're told that Bibi Hawa was created as a companion for Nabi Adam. And this sort of places a kind of ontological priority of Nabi Adam over Bibi Hawa. I was wondering if Ayatullah Saanei had the traditional creation story and how it's taught to us traditionally. The second question was about the differences between men and women, and how these are simply physiological differences rather than an essential difference in our souls. But some would argue that physical differences also have psychological consequences. So, for example, the way that hormones play a role in psychology. Did Ayatullah Saanei ever refer to psychological differences in his methodology? Thank you.
Regarding the first question, Ayatollah has explained about some narrations in the Islam. He believes that most of these narrations come from Jews and some from Zoroastrians to the Persian or to the Arabic narratives. You know, the main criteria for Ayatollah was that he compared narratives to the Quran. If it was not according to the Quran, he rejects all. So Ayatollah believes there is no place for this kind of narratives in Islam, and so rejects all of them. Regarding your second question, yeah, he believes that man and woman, they have different psychology, different, but it do not mean if we have different personalities, we have different rights. It would not affect the rights of the people. It's just different personality. We are women, you are men. No matter that we are different in psychology or physiology. He believes in the same rights. Also in the same rights, it don't mean that in all area of the fiqh, he believes in the exactly the same right. For example, in the inheritance, he believes that man can earn from his father twice because women receive mahriya and nafaqa. If I talk about the equality of the right, there is some consideration, but Ayatollah believes if women receive nafaqa and mahriya, it could be somehow equal. If any more questions? I hope that my answer be used for the question.
Thank you very much for that answer, Dr. Matsuma. I'm going to go to a question from the YouTube page from Munzila Raza. Sorry if I'm pronouncing that incorrectly. It's a question to Miqdaad Versi. Wouldn't it be appropriate to say taste of Sharia is more reflective of something like shuhra and is not as grounded in substantive and robust Quranic principles like Ayatullah Saanei is?
Thank you for that question. Shaykh Kumail probably has far more insight on this than me, but just my thoughts on this. Ayatollah Khoei, in his derivation discussion on the topic, is very clear. He talks about Dhuq al-Sharia, and he in that discussion of Dhuq al-Sharia with regard specifically to the mujtahid being a woman, he specifically talks about fiqhi rules or principles. He talked about the principle that Allah loves women to be covered. He talked about the principle of Allah loving women to take care of household affairs. He talked about the principle that Allah does not like a woman being on show. It is very difficult to argue that these specific things are shuhra. These are what he understands to be the principles that he has derived from his understanding of Sharia, from the texts of the Sharia, and therefore from a holistic reading of Sharia. So Ayatollah Khoei, in my view, and of course others have far more insights and knowledge and research and background on this, but from this one ruling, it's quite clear to me that he's not basing on Sharia at all. He's basing it on textual evidence to get his view of this ruling, and therefore I would argue it's quite similar in terms of textual understanding, a worldview. Dr. Hamid Mavani talks about this being a Quranic Weltanschauung, a worldview using the Quran or Islamic law. And I think that really, Dhuq al-Sharia seems very similar in many respects to that. I mean, there might be some differences, but in principle, they seem very similar. So that's the key point I want to get across. And so I don't think it's based on Shuhra. I think it's really much based on text and I get to that conclusion because of what Ayatollah Khoei says in his wording on that ruling.
Thank you for that. A question from Rabab Zaidi to Shaykh Rajani. What percentage of the present-day Hawza population would you say is open to progressive perspectives? So it's a difficult question, but it's an interesting one. I guess trying to ascertain the extent to which progressive perspectives will be facing a backlash or are facing a backlash. It's relevant to think about the percentage of the Hawza that is thinking in these terms.
Yeah, I'm afraid I would be able to give any specific answer in this regard, but I do underscore the importance of this question, like, how much the discourses are there in the Hawza. I could say, like, in every such institutions, we have these voices, but it's not to the extent that we might like to make it, like, an individual sort of percentage. So, yeah.
I mean, one of the interesting things that I found from listening to the speeches, the presentations today, is that much of the impetus for progress, if you like, is coming from within and from rather than pressure from outside the institution of Hawza. That it was reading about the history of Ayatullah Saanei. His own experience of implementing Islamic fiqh in practice in Iran led to some of his thinking or rethinking about fiqh, and it's interesting to me to know to what extent there is outside pressure on the Hawza to reform, whether they are hearing, if you like, and engaging with progressive voices from outside the Hawza that are saying certain elements of fiqh are difficult, at least, to justify in a modern context. If I could ask that question to Shaykh Kumail.
Precisely. I mean, as I was trying to convey in my presentation, like, new questions, new challenges would not be necessarily be addressed with the old techniques, simply for the fact, like, those questions were not conceptualized in earlier days when these narrations were reported, transmitted, or even studied. Right. So for that reason, we need to have that sort of a nuanced discussion, and needs to be read between the lines. To go not only restrict ourselves to the letter of the law, but to go for the spirit of the law. So that is exactly what, like, some of the progressive scholars are trying to formulate in their discourses.
Thank you. I'd just like to pick up on Sister Afifa's question again. She's just come back to Dr. Masuma to ask for some clarification, essentially, in relation to the creation story. So, Dr. Masuma, you've explained that Ayatullah Saanei has critiqued, if you like, the sources of some of the stories relied on, both the creation story as well as other stories that are relied on to underpin some of the rulings on gender disparity, if you like. And the question from Sister Afifa is, traditionally we're taught that Hawa was created to provide companionship to Prophet Adam, which places ontological priority of man over woman. Did he have any views on that particular story? Did he question that story about, who was created first and for what purpose was the other created, if you like?
As I explained in my speech, Ayatollah believes that there is no difference in the creation. Man and woman are created from one single source, so they come to the creation at the same time. Body, spirit come to the creation at the same time. There are a kind of a story that we grow up with as a child, as a girl in Islamic community, that we should accept that we are inferior to the man, and it's really revolutionary for us. I'm 50 years old, yeah. It's just 3 or 2 years that I have here, and I really believe that I'm same with the man, because I thought that if I think I'm really equal with the man, I have all equal rights with same as the man. It's a kind of making distance with the Islamic beliefs. So I know for your how it's difficult as a woman that we raised in a traditional Islamic community, and it's better I say very conservative Islamic community, to believe that there is just one single source for talking about the woman and man, and that's Quran, because Quran is very mahjur in Islamic community. I said I'm political scientist. It was my difficulties with the rights of women and minority that brought me to the jurisprudence, and I'm sure I'm not qualified as Dr. Kumail and Mr. Miqdaad to talk about the Islamic subject. I forget what I want to say. Sorry. Sorry.
Thank you. Yeah. But in short, his understanding of the story of creation is that man and woman were created at the same time from the same source, and that's where their equality stems from. Okay, I have another question I think would probably be best answered by Shaykh Kumail. Do you consider Ayatullah Mohaghegh belongs to the progressive camp?
Well, these are like, categories which we have devised lately, and we are not sure his office or like his students would like to consider. As far as Ayatullah Mohaghegh is concerned, certainly he had progressive ideas. Within the framework of traditional school, he advanced some of his ideas and theories, which are quite interesting. However, we need to make a distinction as far as the scholars are concerned between political affiliations and political issues surrounding and concerning these scholars, because see, some of the scholars had some sort of controversies surrounding them as far as politics is concerned, and for that reason they might be under limelight in one way or other. So partly Ayatullah Saanei, I would consider his reputation comes from the same issues, because he was closely affiliated with some of the political parties in Islamic Republic of Iran, and for that reason he gains that reputation. Otherwise, as I mentioned in my presentation, there comes like other scholars as well who were quite innovative and revolutionary in their thinking, in their approach, and in their study and their contribution. Coming back to Ayatullah Mohaghegh, some of his fatawas certainly yes, but he did not come up with a framework which would be he would be consistent in terms of his fatawas. So I don't see that from Ayatullah Mohaghegh. To sum up, there are opinions which certainly appears to be progressive, rightly appears to be progressive, but I don't see the framework which I see from Sayyid Kamal Haidari.
Can I ask another question from me, exploiting my role as chair here and this privileged access to the panelists? I mean, my experience is working for the Law Commission of England and Wales. We worked on law reform, so in a completely different context to Islamic law, of course. But one of the things that we found significantly helpful is consultation. So you consult the public on the implications of proposals, reform proposals. And then also there would be an equality impact assessment performed as part of the proposals for reform to assess the impact on different groups of a particular proposal. So I guess it's an institutional question when a marja like Ayatullah Saanei, as if I understand his approach correctly, takes a focus, or is heavily concerned with impacts, with the justice of the impacts of his rulings on particular groups, and places a significant emphasis on freedom from injustice and oppression as a foundational principle in the way he derives his rulings. Does that kind of approach require further institutional reform within the Hawza to ensure that the Hawza is able to assess the impacts of the rulings that it issues on the wider population and how they do impact the population?
Let me give a couple of sentences because Shaykh Kumail will probably have the best answer. My thoughts are, if we look at the tradition, I feel like the majority of Shia fiqh is very what I term, and I don't think this is a technically sound term, but I call it input focused, based on text, based on certain things that are there. that's where the rule comes from, independent of impact. It doesn't matter what the impact is. Almost knowing about the impact might even blur me from being authentic to the text. And I feel like the vast majority of tradition is like that. So when it comes to the new approach of understanding justice, and really interestingly with Ayatullah Saanei, he uses this idea that the Jahiliyyah at their time, he says that the Jahiliyyah, they were critiqued for being unjust, and their response was, but we are following our text, we're following what our forefathers told us, right? And so therefore the idea of how you determine justice has to be a subjective one based on the society you live in. And given he goes down that route so explicitly, I agree with you that there is a big value in understanding output and therefore what might happen as a result. I would note two things. That we notice that this does happen to some extent with some scholars. So for example, Ayatollah Fadlullah was known quite a lot for listening quite broadly, and after listening he actually revisited the text and then came up with an interesting interpretation of that text, which perhaps might have been different, but it wasn't theoretically, at least, based on the output. It was based on him just re-looking at it in the same way. And I think it would be very interesting or different to see that an impact would actually entirely remove the actual textual implication. That I don't think I've seen that many examples of, other than with Ayatollah Saanei. Perhaps you could argue on blood money and stuff, maybe, but as a whole I haven't seen that happen that much. Shaykh Kumail probably can answer better.
I would say, like, Zahra, your question is the fundamental question to understand the whole thing. I think that question sums up everything as far as the way the Fuqaha thinks. So building on what Miqdaad has eloquently addressed, fiqh is seen, like traditional Shia fiqh is seen as something to be derived from text, and text is the whole and soul thing. So for everything, you don't refer to what is happening in the public life, you just find the text. If you don't find the text, you would find a similar text, right? And if you don't find a similar text, you would go for some principles which are again derived from the text. So, there is no scope in traditional framework. There is no scope to look at those impacts or to look at broader questions which the 21st century is grappling with. So that's and comparing to, as you were saying, like, the modern law, or like, English, or like Wales law, or like any other like Western code of law, if you were to concern, that is not devised or designed on a particular text. So there is nothing left for them to defend or to safeguard something. Whereas Fuqaha, in traditional sense, as I was discussing, the letter of law is quite central to their thinking.
Okay, thank you for that. I have a question from Sister Asia Doiji. Sorry for the pronunciation. It's a question for Miqdaad Versi. If the Quranic verse on needing 2 female witnesses for 1 male witness was meant for a specific instance and can be contextualized with regards to other matters of expertise, is that to say that not all Quranic verses are directly applicable in their literal sense and can be contextualized?
Thank you. What's interesting is that I think that others might be able to speak about this better, but Ayatollah Saanei really didn't use context very explicitly as much as perhaps others in the sort of more reformist liberal framework might do. His argument against the 2 witnesses to 1 was not based on the context has changed. His argument was based on the fact that the Quranic verse is very clear of what the rationale is for that discrepancy. The Quranic verse says, so that one might remind the other. And therefore, he argues that the mention of women is incidental to that verse. And actually, the key point here is expertise. And he backs that up by the Bina al-Uqala, how rational people think about these things, and noting many other situations within Islamic law where there's consensus, where women have a greater value of their testimony on women's related issues specifically compared to men. And if you look at that as a whole, for him, the rationale is very clear that within that framework, within that law, expertise is the driver. So he's not actually talking about a contextual difference. Now, the response might come to him saying, well, actually, there needs to still be a justification why at that time that verse did say that women had less value in their testimony. And in that context, I haven't seen if he has been asked that question, but my guess to his response would be at that time, women weren't involved in monetary affairs and financial affairs very much because of the society they're living in. And therefore, their understanding might not be there. And therefore, that's why that verse explains it. And by giving that explanation, it actually opens the door up to saying it's the rationale behind the law, which is very clearly textually given. Whereas that, and the reason why I want to compare that to inheritance, where the 2-to-1 ratio still remains in place, is because for him, the rationale of that is justifiable with an equality justice framework because of other things. Because, for example, the men have to are within his understanding, required to pay for the expenses, etc., of a family unit, and therefore, because of that, this inheritance discrepancy is justifiable, and the Quranic verse does not give a rationale on these things in the same way that there was a rationale given on the witnesses' point. Hopefully that makes sense.
It does, thank you. Dr. Masooma, I have a question for you. In terms of the underpinning principles that Ayatullah Saanei relies on to form his view that women deserve equal rights to men, if you like, or are equal in their worth to men, can those principles themselves be taken to drive or to campaign, if you like, for further equality between men and women in terms of the actual rulings that then derive? So if we use his insights in terms of the epistemological foundations for his fiqh, could that be used to derive at rulings that go even further than the rulings that he arrived at in conclusion to those ideas?
Pardon, I lost part of
Sure,
your voice.
I was just wondering, when I was listening to your talk about the foundations that Ayatullah Saanei relies on in terms of understanding the equality between men and women, and then bearing in mind Brother Miqdaad's conclusion that perhaps Ayatullah Saanei's fiqh or rulings do not necessarily go as far as progressive voices outside the Hawza may request or demand, if you like. Do you think that his understanding of the foundations, so his epistemological foundations for his understanding that he relies on to derive his rulings, could be relied on to derive even more progressive rulings on issues affecting women?
Yeah, I strongly believe to that. And as a great marja, he made the route for some other younger mujtahids. And how a conservative approach is taught in Iran. Ayatullah I read recently in one of the Ayatullah Jannati's books, and that somebody asked in an interview, somebody asked of him that, are you I forget the English word, optimistic about the future of the reformist movement in the house, and not in the political sense. I don't mean in the house. And he said yes, and the reason was that, see, I'm alive. Did not kill me. Still alive. Did not kill me. So it means that something happened inside the house. Even we know a lot about the innovative works of Ayatullah Saanei, Ayatullah Jannati, but in the conservative society of the Iran, their thought is not welcome. But in intellectual level, it's really welcome. As you can see, that you have many questions in your in the conference about their thoughts, and I think they can make It was about 1 year ago that the Iranian government formally accepted the blood money of men and women is equal and should be paid equal. It was a really great progress.
Fortunately, Dr. Masoom's line has cut for me. I assume it's the same for. That was actually a very interesting insight she was giving us. So I hope we will find more information about it in her writing. I know she's published about Ayatullah Saanei in several places. So unfortunately, we don't have the rest of her answers to that question. But it's good to know that Ayatullah Saanei was optimistic about progress, which hopefully will leave us on an optimistic note about where the Marja'iyya is heading in terms of the rights of women and other minorities, as well as other difficult topics facing Islam in the times that we live in. On that note, I'd like to thank the speakers for our second panel for their insights and for the information they have shared with us. And I would like to hand over to Sister Maryam Asaria to conclude the program.
Thank you, Zahra, and thank you to all of our brilliant panelists. And thank you to all of you for joining us today. I'd also like to say a special thank you to those behind the scenes for organising all the tech, enabling this program to take place, and also for all those that have helped to put the event together. So inshallah, we look forward to seeing many of you again soon at our future events at SICM Mahfil Ali. To find out more about our programs, check out our website, sicm.org.uk. So that's SICM.org.uk. And inshallah, see you soon. And we pray that everyone stays safe during this time. Wassalam.